Chair, I call Mr Christopher Atherton.
Thank you.
Please repeat after me.
I do solemnly,
sincerely and truly, declare and affirm
that the evidence I shall give
shall be the truth, the whole truth,
and nothing but the truth.
Thank you. Please sit down.
Thank you.
Mr Atherton, you've prepared a statement for this inquiry dated the 13th of November 2025.
That's correct.
And are the contents of that statement true to the best of your knowledge and belief?
They are.
Mr Atherton, you're employed by Nottingham City Council as the Strategic Director of Adult Social Care and Health.
That's correct.
You qualified as a social worker in 2009.
Yep.
And you specialise in adult social care.
That's true, yep.
You previously worked at Haringey Council. You worked as a frontline social worker between 2009 and 2015.
That's correct.
And thereafter, in about 2015, you took the role of a principal social worker. And from 2018, you became the head of quality assurance and development at Haringey.
That's correct.
And it's in 2025, I believe, that you started work at Nottingham City Council.
That's correct, June 2025.
Thank you, as the Strategic Director of Adult Social Care and Health.
Yep.
And you produced your statement in response to a Rule 9 request from the inquiry, and you say in your statement that you were considered the best placed person to assist the inquiry from the perspective of Nottingham City Council.
That's correct.
I want to ask you about the role of the local authority and social care in mental health services. Now, if you'll forgive me to do that, I need to take you through some of the statute and guidance first, if that's okay.
Absolutely.
So can I please start with the Care Act 2014? So it's RLIT 0000035001. So Section 1 of the Care Act, the general duty of a local authority in exercising a function under this part in the case of an individual is to promote that individual's well-being. That's the starting point of the Care Act under Section 1. If you just go over the page, please, we'll see that well-being in relation to an individual means that individual's well-being so far as relating to any of the following, and we see that at B it refers to mental health and emotional well-being. At E it refers to participation in work, education, training or recreation. At F, social and economic well-being. At G, domestic, family and personal relationships. At H, suitability of living accommodation. If I can take you to the next page, please, Section 2 of the Care Act. A local authority must provide or arrange for the provision of services, facilities or resources, or take other steps which it considers will contribute towards preventing or delaying the development by adults in its area for care and support. So there's a focus there on preventing needs before they arise. Is that correct?
That is correct, yes.
The guidance tells us something about that. Can I please take you to RLIT 5034022? So this is the Care and Support Statutory Guidance. It's the statutory guidance that sits behind the Care Act 2014. Is that correct, Mr.
That's correct, yes.
Paragraph 2.40 states that at 2.40, prevention should be a consistent focus for local authorities in undertaking their care and support functions. That's correct, isn't it? However, there may be key points in a person's life or in the care and support process where a preventative intervention may be particularly appropriate or of benefit to the person. Approaches to identifying those people who may benefit from preventative support should consider how to locate people in such circumstances. For example, and the second bullet point refers to hospital discharge, doesn't it?
It does.
So focusing upon hospital discharge there, and also requiring the local authority to have in place measures to locate people who might be undertaking hospital discharge and might need care and support. Is that correct?
That's correct.
If I can take you to the next page, please, paragraph 245. It refers to contact with a person who is identified as being able to benefit from preventative support may lead to the local authority becoming aware that the person appears to have needs for either or both care and support, or support in a role as a carer. This appearance of need may trigger the requirement to carry out a needs assessment. I'm going to come back to needs assessments in a moment if I can. It then goes on to say in the next sentence, however, where a local authority is not required to carry out such an assessment under the Care Act, it should nonetheless take steps to establish whether the person identified will benefit from the type of preventative support proposed. So it makes clear that preventative support should be considered even where there's no requirement to undertake a needs assessment. Is that correct?
That is correct, yes.
Can I take you back to the Care Act itself? So RLIT 5035, page 23. This is section 3 of the, apologies, page 0004. Thank you, I'm grateful. A local authority must exercise its functions under this part with a review to ensuring the integration of care and support provision with health provision and health-related provision where it considers that this would promote the well-being of adults in its areas. So it's looking there at prevention, at integration with health,
Yep.
and also, once again, at the issue of prevention. We see that, don't we? Over the page, please. Section 4(1), a local authority must establish and maintain a service for providing people in its area with information and advice relating to care and support for adults and support for carers. Now that advice, that information about that can be general advice you give to the whole area, can't it?
Absolutely, yes.
But it can also be what's called targeted advice you give to a specific individual as regards care and support.
That's correct.
Can I just take you to the guidance in relation to that, please? It's RLIT 34, page 23. Sorry, can I take you to page 20? Yes, 23. Apologies. Page 35, please. (3.26). Local authorities working with their partners, that could be healthcare,
Yes.
must use the wider opportunities to provide targeted information and advice at key points in people's contact with care and support, health and other local services. These include, but are not limited to, known trigger points during a person's life, such as, and the third bullet point gives an example of hospital discharge, once again, as a trigger point for considering support, information and advice. Can I take you back, please, to the Care Act? Just a couple more provisions, if I may. Page 10 of the Care Act, so it's RLIT 35, page 10. This is section 8, which sets out the types of care and support that might be provided. 8.1a, accommodation in a care home or in premises of some other type. Some other type, that could be, for example, supported accommodation or something of that nature, is that correct?
That is correct.
Care and support at home or in the community. So it could be someone coming into the home or helping someone to access the community in some way. That's included there.
Yep.
C, counselling and other types of social work. D, goods and facilities, not relevant here. And E, information, advice and advocacy, which we've just touched upon. And then below, section 9, assessment of an adult's needs for care and support. So we're getting onto the assessment part of it now rather than the principles that we've looked at. It says, where it appears to a local authority that an adult may have needs for care and support, the authority must assess whether the adult does have needs for care and support, and if the adult does, what those needs are. And it says at subsection 2 that that's a needs assessment. Do you see that?
Yes.
And the duty to carry out a needs assessment applies regardless of the authority's view of the level of the adult's needs for care and support or the level of the adult's financial resources. Final provision of the Care Act, please. Page 15. This is the eligibility criteria. 13.1 sets out that where a local authority is satisfied on the basis of a needs or carer's assessment that an adult has needs for care and support, or that carer has needs for support, it must determine whether any of the needs meet the eligibility criteria. So step 1, what are the needs?
Yep.
Step 2, are they eligible?
That's correct.
And well, let's have a look at the guidance in relation to that. If I take you back to that, so it's RLIT 34, page 88, please. Paragraph 6.6 tells us that the assessment and eligibility process provides a framework to identify any level of need for care and support so that local authorities can consider how to provide a proportionate response at the right time based on the individual's needs. Prevention and early intervention are placed at the heart of the care and support system. And then if I could take you to page 90. This is touching upon 6.13. Local authorities must undertake an assessment for any adult with an appearance of need for care and support, regardless of whether or not the local authority thinks the individual has eligible needs or their financial situation. So you need to assess even if you don't think they're going to have the eligible needs. Is that correct?
That is correct. If there is the presentation of care and support potential needs, then yes, absolutely.
Thank you. Can I take you to page 110? Paragraph 6.100 touches upon eligibility. The national eligibility criteria set a minimum threshold for adult care and support needs and carer support needs which local authorities must meet. All local authorities must comply with this national threshold. Authorities can also decide to meet needs that are not deemed to be eligible if they choose to do so.
Correct.
So needs assessment first of all.
Yep.
Then you look if the eligibility criteria is met. If the eligibility criteria is met, you have to provide the care and support. Is that correct?
That is correct.
If the eligibility criteria is not met, it's a discretion that the local authority has. Finally, from the guidance, can I take you to page 117? .113. Individuals with fluctuating needs may have needs which are not apparent at the time of the assessment, but may have arisen in the past and are likely to arise again in the future. Therefore, local authorities must consider an individual's need over an appropriate period of time to ensure that all their needs have been accounted for when eligibility is being determined. So if a patient, for example, or a person has fluctuating mental health needs,
yes,
it's really important when undertaking the assessment of needs and eligibility to consider what their position is when they're unwell.
Yep.
Now, we've talked about the eligibility criteria. Those are governed by a set of regulations, aren't they? Can I take you to that, please? It's RLIT 37. The Care and Support Eligibility Criteria Regulations 2015. Section 2. An adult's needs meet the eligibility criteria if the adult's needs arise from or are related to a physical or mental impairment or illness. In this particular matter, we know that VC had a mental illness. 2B, as a result of the adult's needs, the adult is unable to achieve 2 or more of the outcomes specified in paragraph 2. I'll take you to those in just a moment. And as a consequence, there is or is likely to be a significant impact on the adult's well-being. So just to take you to a couple of those specified outcomes, can I take you to 2E? Being able to make use of the adult's home safely. It's right that use of the home safely can include whether a person can safely access their property and come and go. Is that correct?
That is correct.
The inquiry's heard evidence of a number of incidents of aggression and violence involving VC towards those living in and around his accommodation. Mr. Atherton, if the Chair finds those incidents as a fact, would VC, under the regulations, be deemed, when unwell, not to be able to use his home safely?
So in relation to that, we would look at it from the perspective of their safety themselves, so their ability of being able to come in and out of the home, to utilise the environment itself, and to ensure their own safety. It wouldn't necessarily apply to the safety of others when we're assessing the person's safety or managing their home safely.
When people get involved in incidents, it's common sense that they can get injured themselves, can't they, if they're involved in incidents of violence or aggression?
That's correct, yep.
So that can compromise their safety as well as the safety of others, can't it?
It could, yes.
So in those circumstances, it seems that VC, on that factual premise that I've put to you, wouldn't have been able to use his home safely, at least when he was unwell.
Yeah, I think if you're the way in which you can interpret it, it can absolutely could be interpreted in that way, yes.
Those incidents with the neighbours significantly impacted VC's well-being, as he had interactions with the police, health interactions arising from it, and of course no one wants to be involved in incidents of aggression and violence, and so therefore it seems that 2C is met, doesn't it, that that has a significant impact on the adult's well-being.
Yes.
Can I take you to 2G, please? Developing and maintaining family or other personal relationships. The guidance points to this being engaged where a person is isolated because of their needs. And that can be because of mental health needs, can't it?
It can, yes.
Now, if the chair concludes that VC was socially isolated from the community around him because of his mental health, including from other university students, from housemates, that would be a basis for concluding that 2G was met, wouldn't it?
But it also talks around developing and maintaining family relationships, of which I'm aware VC was. So, you know, there'll be an element there which would still be being met with the relationship he has with his family.
But in terms of personal relationships, if the inquiry finds that he was not making relationships with other students on his course, with housemates around him, then there were difficulties developing and maintaining personal relationships, weren't there?
There would be if that was related to his mental health condition, and if there were challenges with him engaging in those relationships, yep, that would be correct.
Such isolation meant that VC was difficult to monitor. He didn't have contact with others. Signs of relapse were not picked up. Therefore, it appears on that basis that his isolation significantly impacted on his well-being. And that brings us back to 2C, doesn't it?
Yep.
Over the page, 2I, making use of necessary facilities or service in the local community, including public transport, recreational facilities or services. Well, we've got evidence before the inquiry that VC, when unwell, did not engage with mental health community services on a number of occasions. So that would be engaged, wouldn't it?
So a lot of the time how we view that is their ability of going out and accessing the community more broadly, so going out and engaging with you know, the community provisions of community services, going to and from their accommodation, having the opportunity of being able to engage with that. I suppose you could look at it through the lens of the engagement with mental health services.
I mean, community mental health is a service.
It is a service, yeah.
It's a very important service in terms of someone's well-being, isn't it?
Yes, it is.
And if he's not making use of it because of his needs, then that would be qualified. Then we'd meet 2I, wouldn't we, there? And clearly, not engaging with mental health services is going to be detrimental to someone's well-being.
It would be detrimental to someone's well-being, absolutely.
Mr Atherton, it follows, therefore, that if the chair makes those findings, I put those matter for the chair, but sure. if the chair makes those findings, VC not only had care and support needs, he had needs that met the eligibility criteria under the regulations.
If as opposed to cross, and that's the chair's view, then yes.
And therefore, on that basis, the local authority was required to meet his needs.
It would be on the basis of the local authority being made aware of that and undertaking the assessment, yes.
In terms of an assessment, it's right that VC was never assessed under the Care Act 2014 by the local authority, is that correct?
That is correct.
And therefore, because he wasn't assessed, no needs were provided under the Care Act.
That's correct.
In particular, he wasn't assessed at the points of discharge, which the guidance we've seen identifies as a potential trigger point for an individual's needs.
That's correct.
Now, aside from the Care Act, the local authority also has a distinct duty, doesn't it, to provide aftercare in circumstances where a patient is discharged under Section 3 of the Mental Health Act.
That's correct.
That duty is under Section 117. Let me take you to that. It's NHSE 40312, and then it's page 355. It's the guidance in relation to Section 117, please. First of all, it's right that care services or aftercare services under Section 117 have to be provided free of charge.
That's correct.
Without assessment as regards eligibility.
That's correct.
And without assessment of finances.
Correct.
So just turning to this guidance here, 33.3, aftercare services mean services which have the purposes of meeting a need arising from or related to the patient's mental disorder and reducing the risk of a deterioration of the patient's mental condition, and accordingly reducing the risk of the patient requiring admission to hospital again for treatment for the mental disorder. Their ultimate aim is to maintain patients in the community with as few restrictions as are necessary wherever possible. And then it goes on to say CCGs and local authorities should interpret the definition of aftercare services broadly. For example, aftercare can encompass healthcare, social care and employment services, supported accommodation, and services to meet a person's wider social, cultural and spiritual needs, if these services meet a need that arises directly from or is related to the particular patient's mental disorder and help to reduce the risk of a deterioration in the patient's mental condition. Aftercare is a vital component in a patient's overall treatment and care. As well as meeting their immediate needs for health and social care, aftercare should aim to support them in regaining or enhancing their skills or learning new skills in order to cope with life outside of hospital.
Yeah.
Mr. Atherton, Ms. VC was discharged twice under Section 3, on the 31st of July 2020 and on the 18th of October 2021. However, on those occasions, the local authority did not assess whether VC needed Section 117 aftercare services. Is that correct?
That is correct.
I just want to understand why that was. Can I take you to your statement, please? So this is WITN 0225001, page 8. Paragraph 26. Once released from detention, you're referring to there, a care coordinator will be identified. That may be the hospital's community psychiatric nurse or an OT, depending in staffing in the trust. If they identify social care needs, they can call in the local authority. When you're saying they, you mean the CPN or the OT?
Well, what I meant by that is the clinical team who would be supporting VC in hospital. They would make a decision on whether there was a requirement under Section 117 that required social care to be part of that assessment process.
So it could be those assisting in the community, it could be those before discharge, the whole clinical team, both
Absolutely,
before and after. Paragraph 28. Overall, however, the local authority is in the hands of the treating hospital when it comes to providing information about patients who are coming up for discharge or have been released. So it appears from your statement, Mr. Atherton, that whether there's a need to assess under Section 117 or under the Care Act was not triggered in VC's case because the clinical staff didn't inform the local authority of any social care needs.
That's correct.
So the decision on whether the local authority has needs and has obligations to meet those needs, that decision is effectively made by staff from another agency. Is that correct?
That is correct. Obviously, we have a number of people under Section 117 arrangements with the Mental Health Trust, so it's a well-established process for referral into the local authority where there are identified potential care support needs.
We've looked at the Care Act. Some of the needs for care and support are more obvious, physical needs, nutrition, hygiene. Some of them are a bit more nuanced, aren't they?
They are.
For example, information and advocacy, issues in relation to perhaps assistance with accessing the community or protecting someone so they're safe in their home, these sorts of things, as I say, a little more nuanced. How did the local authority in the period we're concerned with, between 2020 and 2022, satisfy itself that the mental health staff understood the social care legislation and the guidance that we've been through?
That's a difficult question for me to answer, given that I wasn't in Nottingham at the time and didn't have engagement with this case. I think like I say, the establishment of the working arrangements between the Mental Health Trust, not just in Nottingham, but from a national perspective of that interplay between adult social care and health services and mental health services is obviously very well established. The health practitioners and the clinical team will have a good understanding of what qualifies as adult social care needs, and we see that from the amount of people we're supporting under Section 117. That is an established pathway. But it's difficult for me to talk specifically to that time, having not been here.
Are you aware of any particular training that was given to mental health professionals so that they can properly understand your processes?
I'm not aware, no.
Were there any checks undertaken to check that the mental health staff understood the social care legislation and guidance?
Again, as I was not here at the time, I'm not aware if that took place or not.
Were you aware of any protocols, for example, that would assist mental health services to identify which cases they maybe need to pick up the phone and speak to a social worker about and say, what about this case or that case? Some sort of guidance on the ground?
Again, I'm not aware of particular guidance at that time and what would have been available. I am aware that there are good working relationships from a professional level, from professional to professional, between the Mental Health Trust and adult social care, and at that time there were. So whether there were informal conversations that took place between practitioners and clinicians, that may have occurred, but I wouldn't know for sure.
We've still got your statement on the screen. Can I take you to paragraph 27? Whilst the division of social health and social care needs like this makes logical sense, there is a danger that vulnerable individuals can slip through the gaps where their needs do not fit easily into definitions of health or social care. Isn't the point of Section 117 to make sure that people don't slip through the gaps between medical and social care?
It is, yes.
Isn't the way to ensure that no one slips through the gaps to make it necessary as a minimum that mental health service notify the local authority when a patient is being discharged from hospital and going into community mental health services?
I think you strengthen that process by having teams that sit together and having social work expertise that sits within that clinical decision-making team. I'm not aware that was what was in place at the time. That was certainly strengthened moving forward, ensuring that you had that level of expertise sat as part of that ongoing discussion.
But we don't know whether there was social work involvement in any particular discharge. So we're talking here about safety nets and making sure there's no gaps. Isn't the simple way to deal with that to make it a duty or requirement for the clinical services to tell the local authority about what is happening at the point of discharge, given that it's a trigger point, as we've seen in the guidance?
Yeah, absolutely. I think there is a challenge, and again, from a national perspective, around the resource available both between the trust and the local authority or local authorities in their engagement, their ability for every single patient that goes in to be informed of the discharge, potentially where there isn't necessarily a requirement for care and support or ongoing care and support from adult social care. So there's some challenge there in being able to do it in a way that doesn't flood local authorities with information around potential discharges of patients where there isn't a requirement for adult social care to be involved long term. I'm not referring to this case, I'm talking more broadly.
Adult social care have got an obligation to undertake needs assessment and to meet needs.
Where that's been identified, yes, absolutely.
You're relying upon other professionals to identify the trigger point for when you might need those needs. You're not aware whether those individuals have got proper training in relation to the Care Act. In those circumstances, isn't the only way to avoid there not being gaps to ensure you're told about these discharges?
It would ensure a level of oversight. Again, we would still be relying on the clinical team to provide information relating to those individuals, so we'd be informed of that. It's going to make an informed decision, but yes.
And then you could undertake, for example, a screening assessment.
Absolutely, yeah.
With all the knowledge and those nuances in the Care Act that we've looked at, that could then be applied in that screening assessment, couldn't it?
It could be, yes.
An alternative route to ensure the local authority remains engaged and there's no gap in the net is for the AMPs to potentially stay involved, the approved mental health professionals. That's an alternative way, isn't it?
It is an alternative way. It's obviously not stated that in any of the legislation that we have. It's a very bespoke role. You know, what I would say in relation to the AMP role is that, you know, from a national perspective, it's a challenge nationally around having trained AMPs in place. We have around 40 that sit across adult social care teams in Nottingham City, but it's a challenge with the demand coming through to ensure the assessment as defined by the legislation is carried out. The ongoing involvement would make it challenging. You'd need significantly more AMPs into the service to be able to ensure you've got a broader wraparound provision to be provided if that was something legislatively that was suggested moving forward.
The latest Department of Health and Social Care guidance encourages there to be work on discharge during the whole period of detention, doesn't it?
That's right.
The AMP is there at the point of detention.
Yep.
They have some understanding of the case at that particular point. If they can remain involved just as a sort of focal point at the local authority and then can be there to, again, fill that gap, make sure the safety net is there at the point of discharge.
I think I think we would welcome the ability of being able to have a greater level of involvement moving through. I think anything that connects adult social care and health services together in making some of those decisions would be welcome. But again, I would point to, you know, the scarcity of our AMPs to be able to undertake that role and also respond to the amount of mental health act assessments that they're required to do.
Can I take you to document PAGR 5025, please, 000002. This is a medical record concerning VC. It's dated the 19th of October 2021. And I want to take you to the entry timed at 1923 and the last paragraph there. The second sentence, City Social Work, that's probably Nottingham City Council, rung this afternoon as they had received a referral for a NOA. What's an NOA?
I'm not sure this is a health recording. I'm not sure what that relates to.
CNEP explained this was due to Valdo being NFA, no further action. However, he has not secured accommodation. I think that's probably supposed to say now secured accommodation and therefore does not require further social work support. Did you see that?
Yes.
So it appears to be the social worker from Nottingham City Council contacting the ward about discharge.
It would appear to be that case, yes.
And particularly about accommodation.
That's what it states, yes.
VC was formally discharged from Section 3 detention, albeit he was still in the hospital. He was formally discharged from Section 3 detention the day before. Would you expect health and social care to be in touch with each other before the discharge and working out matters of accommodation?
I would expect that, yes, if there was a role for adult social care to be involved, particularly if there was an issue around accommodation.
We can see that there was a discussion about accommodation. We don't know exactly what the full conversation was, but it seems to be quite a short note. There's certainly no information here to suggest that the social worker was in any way able to assess whether VC's accommodation was suitable or not. Do you agree with that?
I would agree with that.
And the social worker doesn't seem to be alive to the problems that VC had with others in and around his accommodation previously.
Yeah, given the information that's on the screen, that wouldn't appear to be the case.
And no suggestion the social worker was alive to any of the other social care needs that VC may have had that we touched upon earlier in terms of socialisation, accessing services, those kinds of matters.
That's correct.
So on the 19th of October 2021, the local authority were aware of a discharge, but didn't undertake an assessment of VC's needs.
We certainly didn't undertake an assessment of VC needs because there's nothing on our record system. Obviously, this is a note on a health system that's been recorded by a health practitioner. Other than what's written on that, there's not much context to that or the social worker's involvement. As stated, there wasn't anything on our records that talked to any social worker involvement other than the AMP involvement as part of that assessment process.
If with the result of this information, some sort of... We've discussed a screening assessment as a potential way forward. If a screening assessment had undertaken, given that we've noted that VC has eligible needs under the Care Act, it no doubt would have led to a package of support under the Care Act or under Section 117.
I don't think I agreed that necessarily. I think you made the point it was for the Chair to make that decision based on the information he had. So that's not... I'm not making that assumption that he was eligible, certainly from the information that we've looked at, and I appreciate obviously the inquiry has much more information than certainly what I've had since making the statement. It didn't appear that the thresholds were met around eligibility, but I appreciate the inquiry has a lot more information than I do when I made that witness statement.
On that basis, so on the basis that the Chair makes those findings, and I did frame those questions very much in that way, on the basis that the Chair makes those findings, the eligibility criteria was met under the Care Act, wasn't it?
If that's what the Chair deems, yes, absolutely.
And given that all of those criteria were met because of VC's mental health, that would have likely mirrored, maybe not the same, but it would have mirrored the Section 117 aftercare package that could have been put in place.
Yes, on that basis it would do.
And that package would have served as a second set of eyes on VC, wouldn't it?
Dependent on what was commissioned as an ongoing level of support that would be required, and obviously that takes many forms, as you pointed out earlier in relation to the Act of what it deems as the requirement for the local authority, it absolutely may well put ongoing support around him that could present extra additionality of oversight. Could have been perhaps support to take medication? That is a health function, it's not a Care Act function. So
reminders, promptings? Reminders and prompting,
if it's incidental and ancillary to the other care and support that's being provided, then yes, we could provide prompting around the medication. If that was, again, that would be around the broader, wider care and support that would need to be in place for him for that prompting to take place.
Social worker could have been encouraging as regards information and advice for socialisation or support groups or other things in the community potentially that weren't clinical interventions?
Absolutely. If we're doing the assessment or there is identified needs either under Section 117 or the Care Act, we would looking at VC as holistically as possible around what additional support might be put into place to support him in achieving his outcomes.
Could be assistance with accommodation?
It could be assistance with accommodation if it was related to his care and support needs.
And just by having the social worker or the local authority involved, you would have another set of eyes there to see if he's not taking medication or if there's a relapse or any concerns of that nature.
Yes, if there is a level of ongoing support that is in place, particularly on a daily basis, and I would probably, I would state with the identified care and support needs that you have highlighted as potentially being eligible under the Care Act, that wouldn't necessarily require a day-to-day level of support going in and seeing him. A lot of where we look at prompting around medication is done so because we've got our commissioned care support going in place to provide support around toileting, washing, dressing, those elements, obviously, which VC didn't have those, certainly from the information we have, those identified care and support needs. But yes, while there are support workers going in or care workers going in, there is the opportunity in which to, for them to identify whether medication is being taken or prompting the person to take medication. But the responsibility around taking medication or the medication elements does sit with health.
19th of October, we've seen the record, we just touched upon it. If we could take that off the screen, please. That was a discharge under Section 3. If a community treatment order had been in place at that time, would the position be any different as regards the local authority's engagement, assessment and support at that particular time?
So because it would be through a community treatment order, the AMP would be back involved in that process for whether the community treatment order would be appropriate or not. Again, whether that potentially, through that process, highlights care and support needs via Section 117, I'm not sure. But again, once that piece of work had been completed, the AMP would step away again, and then it'd be with the clinical team's responsibility to manage the CTO.
So the AMP would have to be involved at that stage?
That's right, yes.
So that would have been an occasion for the AMP to say, these nuanced needs that we've looked at, they're there, and there's a care need, and he meets the eligibility criteria and Section 117. So that would have been an opportunity for a package to be put in place.
Yeah, if the AMP has gone in, and obviously our AMPs are qualified social workers, if they'd gone in and been part of that assessment, and if they had identified that there was ongoing care and support needs, then they could have made recommendations at that point, but it would obviously be on the basis of those needs being identified.
Can I take you to a different duty under the Care Act, please? The Section 42 safeguarding. We go to document RLIT 5035, page 44. No doubt Mr Atherton will be very familiar with Section 42.
I am.
Which applies where a local authority has reasonable cause to suspect that an adult in its area has needs for care and support, whether or not the local authority is meeting those needs, is experiencing or is at risk of abuse or neglect, and as a result of those needs is unable to protect himself or herself against the abuse or neglect or the risk of it. Subparagraph 2, the local authority must make or cause to be made whatever inquiries it thinks necessary to enable it to decide whether any action should be taken in the adult's case, and if so, what and by whom. Now again, the inquiry's heard evidence about an incident on the 25th of May 2020. VC was arrested on the 25th of May 2020 following an occasion where he tried to break into a neighbour's apartment.
Yes.
Resulting in the occupant Faven jumping out of the window through fear and fracturing her spine. Looking at Section 42, as a result of the fracture of the spine and the physical needs, she had needs for care and support at that particular stage.
I wouldn't agree with that. I think there is, obviously defined by the Act, there was a requirement for medical treatment. I'm not aware that that person requires ongoing care and support from the local authority, so it wouldn't meet that threshold. If
they needed a package of support for a matter of weeks at home following the accident, that would be a need for care and support?
I guess not, looking at it, not to be pedantic, but looking at where it would be, she wouldn't have had care and support needs at the time the incident occurred.
No, indeed. Afterwards, after the incident with the fractured spine, if they were out of action for a number of weeks, that's a care and support need under Section 42(1)A.
Again, I would suggest that's ongoing health treatment for a short period of time that wouldn't necessarily constitute a long-term requirement for adult social care. So I don't think that threshold is met.
If the individual had, and again, these are factual findings for others, but if the individual had problems with toileting, personal hygiene, maintaining their home for that period of time, then those are needs for care and support arising from the injury.
Again, it would be on the basis of us being aware of those care and support needs at the time and the referral being made into the service. Obviously, in my experience, I don't think I've ever seen anything for a safeguarding that's been coming for what we would talk for a short period of reablement. I'm not aware of the specifics of the case, but what we tend to look at is what those care and support needs are. And those care and support needs, if we go back to what the Act talks about, it's about the illness or the impairment, and then the criteria being met, and then the significant impacts on the individual's well-being. So, again, because it would be looking at the very specific incident when it occurred, the person didn't have care and support needs when that incident occurred. The idea that they happened afterwards, the safeguarding becomes redundant in the basis of if the individual has injured themselves post it and then there's care and support needs, at the time when the incident happened they didn't have care and support needs. Am I making...
No, I understand. You're saying that they didn't have care and support needs before the incident, but I want you to focus upon the period after the incident. If they've got physical needs for support because of a fractured spine, then, albeit that it might not be long-term, they've got needs for care and support, haven't they?
They may have a period of time where there's care and support being in place. And I suppose that's a question, you're asking the question, it would be helpful to clarify, did they have carers going in providing care and support to them then during that period of time?
I will just, that's a matter of fact for others, but we'll just leave it there. Then can I take you to 42(1)B? Is experiencing or is at risk of abuse or neglect. Now, abuse has got quite a wide definition under the guidance, doesn't it?
It does.
It can include threats of violence and harassment. A neighbour trying to break into someone's property would probably potentially be experiencing abuse, wouldn't it?
Again, I think it goes to the top bit has care and support needs, and then you go to the bit around is experiencing risk of abuse. Again, the person did not have care and support needs at the point of that incident that occurred. So,
but if there's been an incident and it meets the definition for abuse, and these people are still neighbours, then is experiencing abuse. There's that risk, and there's an ongoing risk, isn't there?
I guess your point too is there an ongoing risk? Again, depending on the situation, that there may be.
1C, as a result of those needs, is unable to protect himself or herself against abuse or neglect or the risk of it. If someone's out of action because of a fractured spine, they're going to be quite vulnerable, aren't they?
They are, and again, I'd probably just go back to that point. I could appreciate you're going through each of those levels. The bits around where they can protect themselves is against the alleged perpetrator, and that they should have care and support needs to protect themselves. So again, it goes to the incident that happened at that particular time. The individual did not have care and support needs at that particular time the incident occurred, and therefore Section 42 wouldn't be triggered.
If Section 42, on the factual basis that the Chair reaches, was considered to be triggered, those inquiries would involve liaison with other agencies, wouldn't it?
They would, yes.
There would be a need to speak to the police and to health services. Risk would then be triangulated, particularly in circumstances of an incident like this, where someone's tried to come into someone else's property. There'd be a risk assessment.
Yes, it would be.
The local authority would lead it, because it's its duty under Section 42, but we would have a multi-agency risk assessment being undertaken at this particular stage. That would be necessary to meet the duty under Section 42, wouldn't it?
So, again, as a concept of Section 42, yes, I'd agree with that. I wouldn't necessarily refer it to this, the event that occurred, but yes, as a Section 42 process, if triggered, then the involvement would be to involve other organisations and agencies that may had contact at that particular time, and to make decisions around risk assessment and safety moving forward.
So you'd be looking to make a safeguarding plan?
Yes.
And that could involve not only social care, but also health and potentially the police as well, acting together. Yeah,
absolutely. It's a multi-agency approach. So again, depending on what the safeguarding concern that has been raised is, and the Section 42 inquiry that takes place, it can involve a range of partners, and should do, particularly where those partners have contact with the individual.
And some of that package may well look like the sort of measures that we've already touched upon: medication support, potentially assistance with accommodation, greater social inclusion. These sorts of matters could have been part of that towards VC.
Well, and I guess that's the important distinction, isn't it? Here we're talking about VC being the perpetrator at this incident, or the incident that's been provided, and our duty is to safeguard the adult with care and support needs, who is the alleged victim of the abuse or neglect that may have occurred to them. So it would be to safeguard the individual. Of course, if the perpetrator in any case, and again, I'm not making reference to this particular incident because I don't think it necessarily mirrors up correctly, if there is the responsibility for that to be undertaken, and there is a person with care and support needs that meets the criteria we've identified that is at risk of abuse or neglect, and also the perpetrator may have care and support needs themselves, then of course there would be more of a broader, wider look at the individuals from both sides and what support could be provided.
If the best way to safeguard Faven was to reduce the risks from VC, then the package would have a number of measures in it involving VC, wouldn't it? As I said, medication, social inclusion, potentially accommodation.
Again, the safeguarding itself would primarily look at the victim of the abuse and neglect. The safeguarding process itself would, perhaps it would trigger another part of the Care Act from an assessment perspective, where there is somebody with care and support needs who is the perpetrator, for an assessment process. So as part of that broader, wider wraparound, then yes, that would be triggered.
Even if Section 42 hadn't been triggered, even if someone had just turned their mind to whether Section 42 was triggered, they should have then been thinking, well, does VC have needs under the Care Act? as well, shouldn't they?
I think obviously at the time of the incident and obviously the assessment that was undertaken, that's had the involvement of certainly obviously health colleagues and ongoing health support, and therefore you would look at the expertise of those individuals while working with VC to make a decision as to whether there was an ongoing care and support needs that need to be referred into adult social care moving forward.
It would have a social worker looking at VC's situation and then considering whether there's care and support needs there, wouldn't it?
If that's, again, if that referral had come into the service, then yes, it would be looked at by the social worker who would be picking up the referral being made in by health at that point.
When undertaking Section 42 inquiries, the local authority remains very much at the centre of a multi-agency investigation.
That's correct.
When a Mental Health Act assessment is undertaken by approved mental health professionals, again, through the local authority is at the centre of multi-agency work there as well, aren't they, working
yes,
with
correct.
health? If this inquiry is looking at ways to enhance multi-agency cooperation for patients with mental health needs, the local authority is uniquely well placed to be a focal point or a coordinator for that sort of protocol or multi-agency working.
I think we already are, not in the specific example that you're giving, but certainly around where we look at other risk management frameworks that we operate within, so MAPA and MARIC. We've got a CEREC, so a Slavery and Exploitation Risk Assessment Conference. We've got a complex persons panel. We have a hoarding panel. So there's lots of things we either lead on or part of as part of an ongoing risk assessment for identified individuals. We would expect to obviously be involved in anything relating to a level of complexity where we could bring something of value to those conversations.
I want to touch upon AMP services, please. I'm not going to ask you to give indirect evidence about the actual assessments that were undertaken in relation to VC. I want to look at some higher level issues with you, if I may. Can I start with information gathering guidance? Can I take you to a document, please, WITN 0114004? So this is the first page of a Nottingham City Council operational policy for approved mental health professional services. Do you recognise this?
I do, yes.
And it was extant at the time we're concerned with 2020 to 2022, is that correct?
That's correct.
Can I take you to page 8, please? Apologies, page 4. Section there on information and communication. I'm not going to read it out, it's quite lengthy, but you're familiar with it, no doubt, Mr. Atherton.
Yes, through the information that's been provided, I am aware of it. Obviously, again, at the time I wasn't in Nottingham, but I am aware of the document, yes.
And it continues over the page, please, touching upon further matters, including giving information after a Mental Health Act assessment. Now, it does touch upon this operational policy. It does touch, perhaps if you go back to the previous page, please. It does touch upon gathering information from Care First and Castle. Care First is a local authority resource.
That's correct, yes. At the time, that was what was being used, I believe.
And Castle?
I'm afraid I don't know what Castle is.
It also discusses getting information from healthcare.
Yep.
It also advises the AMP to speak with the nearest relative, as is required under the Act.
That's correct.
There's no mention here about getting any information from the police.
No, there isn't.
Would you expect an AMP to do that if they're considering a risk of violence in relation to an individual they're assessing?
I would, yes. I would expect the AMPs to be in contact with the police, and potentially the police will already may have some involvement, depending on the Mental Health Act assessment that is taking place. But yes, I would agree that police would be an important partner in which to have conversations with.
As an operational policy that this is, would it not be helpful to put that into the policy to assist AMPs?
It would do, yes.
There's no mention either of housing or education.
No, there's not.
Again, in the right circumstances where it's relevant, particularly if there's been incidents at someone's accommodation and they're a university student, that could be very useful as well, couldn't it?
It could do, yes.
Again, useful to have that in the policy, wouldn't it?
Indeed.
Medical information is mentioned. We've heard quite a lot about the Rio Health Systems record. At the relevant times, we're talking 2020 to 2022, there was no formal arrangement in place for social workers to have access to Rio. Is that correct?
That's correct.
Series of ad hoc approaches need to be made by AMPs towards healthcare colleagues to try and look at Rio if possible.
Yeah, I'm aware that some AMPs have access, those probably who are embedded in mental health teams and aligned much more closely to mental health colleagues. Obviously, our AMPs are placed in other teams as well, and I'm aware that the access is not the same for all of the AMPs, and there are ongoing issues with gaining access to the Rio notes.
This lack of a formal arrangement, have any steps been taken to remedy that since the relevant period?
I'm not aware that any formal additional steps have been taken. It's sort of a by-person request that goes into the trust, and the trust makes a decision as to whether we've got that individual can have access to the records.
AMPs cannot make entries onto Rio themselves, can they?
That's my understanding, yeah.
And so they can't update or correct the facts, they can't add their Mental Health Act assessment to Rio, they have to send it and then it has to be added by someone else, doesn't it?
That's correct.
Has that been remedied?
No.
Do healthcare have access to the local authority records?
There is a read across through the systems that we have, our care record system, where there is health colleagues can see some information. Mostly it's from a local authority perspective. We can see information on healthcare records. At present, they cannot see information on our records, but there is work that's being undertaken to ensure that they have similar access, not to all information, but to some agreed information on the system that they'll be able to identify and utilise as part of their ongoing assessment of individuals. But at this current time, they don't have access.
The operational policy also touches upon information that should be given by the AMP after the assessment. Again, it mentions informing the nearest relative, it mentions informing healthcare, but there's no mention of passing on potentially risk information to the police, housing or education. That should be in there, shouldn't it?
It should be in there, yes.
If you could take that off the screen, please. When undertaking a Mental Health Act assessment, an AMP is required under Section 2 and Section 3 to assess whether a patient requires detention with a view to protection of others.
That's correct.
One of the things that they need to look at is whether there's a risk of that patient posing a risk of violence to family, to friends or to people in the community. What training does Nottingham City Council provide to its AMPs as regards assessing the risk of violence to others?
I couldn't specifically talk to that. I know that our AMPs, as part of their re-warranting, have to undertake a certain amount of training to be re-warranted. I don't have the information to hand of what that includes as part of that process, so I couldn't comment specifically on that particular element that you've highlighted.
Where in the guidance or policies that Nottingham City Council has are they advised as regards the importance of protecting the public in the work that they do? So again, the documentation, the policy documentation that we have that talks to the AMP function and the role, which obviously you've highlighted, is the documentation that we have. If it's not referenced within that, then it's not referenced elsewhere. Can we go to document NHSE 0000312, page 24, please? This touches upon the least restrictive option, maximising independence, paragraph 1.2, where it is possible to treat a patient safely and lawfully without detaining them under the Act. The patient should not be detained. So the guidance there refers to detaining where patients cannot be safely treated in the community. So when we're talking about the least restrictive option, it's the least restrictive safe option. Do you agree? Yes, that's how I would read it also, yes. Therefore, it's an oversimplification to refer, as you do in your statement, to detention being a last resort. Do you agree? I would agree, yes. Are AMPs given any guidance or training as regards this nuance that we've just touched upon?
I'm not aware, no.
Since VC's attacks in June of 2023, there's been a rapid review that's been undertaken by adult social care at Nottingham City Council, hasn't there?
That was undertaken in the summer of last year, so July 2025, I believe.
Can I take you to that document, please? It's NOCC 40192. It's dated July 2025. Your statement is dated the 13th of November 2025, but you say in your statement that the report was not yet available. Could you explain why you said that?
Yeah, I think the first draft of that statement, that when the Rule 9 came in, I think I'd been in post for about a month at that point, so that initial statement that had been drafted was accurate. Obviously, when it was submitted in its final form of November, that should have been amended, so apologies.
Since the events of June 2023, has there been any updated guidance or training given by Nottingham City Council to AMPs as regards information sharing, information communication after Mental Health Act assessments, or on how to do a risk assessment?
I couldn't answer that, having not been there at the time. I can only probably talk to, obviously, the last 11 months where I've been in post.
But you've said in your statement you're the person that was nominated as the best person to give evidence. If there had been any new policies or protocols, you should be able to tell us that, shouldn't you?
I can tell you from the period of myself coming in at that time, and I'm not aware of anything from my time of coming into the role in June 2025 of new policy documents or guidance that's been provided to our AMPs since then.
One final document, please. It's PHS 000010. This is statutory guidance that's been issued by the Department of Health and Social Care since the attacks. It's dated the 26th of January 2024. Can I take you to page 18, please? Principle 6. Information should be shared effectively across relevant health and social care teams and organisations across the system to support the best outcomes for the person. And it goes on to say NHS bodies and local authorities should have information sharing protocols in place to ensure there's a clear process and that information is shared between organisations across the health and care system in a secure and timely way. Has Nottingham City Council put in those information sharing protocols?
I'm not aware that they've been implemented, no.
Can I take you over the page, please, to Principle 7? Local areas should build an infrastructure that supports safe and timely discharge, ensuring the right individualised support can be provided post-discharge. NHS bodies and local authorities should ensure there is senior strategic leadership and oversight of the discharge process to reduce unnecessary delays and to make sure that discharge protocols are being followed. Are there any new discharge protocols since this policy has come out or since June of 2023?
I'm not aware of them, no.
Is there senior strategic leadership and oversight of this issue?
There is a lot of engagement strategically between mental health and adult social care services and the wider system for a lot of the work that is undertaking. There isn't one that specifically looks at discharge, but discharge is included as part of some of those wider, broader strategic conversations that take place.
Any particular timescale for when those conversations might lead to new protocols, new information, new training, something tangible?
I couldn't give a time frame that would be an informed one at this time.
Can I take you over the page to page 21, please? 2 pages further forward. Principle 8. Funding mechanisms for discharge should be agreed to achieve the best outcomes for people and their chosen carers and should align with existing statutory duties. NHS bodies and local authorities should ensure that funding mechanisms for discharge are agreed by all partners and should align with existing duties, including those under the Care Act, the Mental Health Act, Children Act 1989, 2004, and Children's and Families Act. Have those funding mechanisms been put in place between the local authority and NHS bodies in the area that you work?
So we have a Section 117 policy that's been developed between Nottinghamshire County Council, the ICB and adult social care. So that's been worked on over a number of months now. I believe it is at the point of sign-off.
Is that going to lead to joint funding mechanisms?
There are already joint funding mechanisms in place where we talk about Section 117. Obviously, there wasn't in the case of VC, but we have hundreds of other people that are supported through Section 117.
Yes, thank you. I don't have any further questions, but if you stay there, others might.
Thank you.
Yes. Good morning.
Good morning. It's all right.
I asked questions on behalf of the survivors. Can I just briefly go back to the review that was commissioned that you were taken to by Mr. Weston, NOCC 40192, please. Thank you. And so this is obviously was commissioned after you came into post in the June. And can I ask you just first of all, before we move to the section I want to look at on page 20 regarding section 117 aftercare, can you help us in terms of VC? We know that you've got mental health social care team north and south, which are very differently configured.
They are.
Has the local authority done a piece of work to identify across the addresses that VC lived at between 2020 through to 2023, where that accommodation engaged, whether it was the North team or the South team?
I'm not aware that they have, no.
All right. But would you agree that essentially, particularly the North team, it works in a less integrated way than the team in the South?
Yes, I would agree with that, yes.
Thank you. And then can I take you to page 20, please? And just picking up on Mr. Weston's theme of what the authority have done since the incident. It's right, isn't it, that this review found some significant systemic failings in respect of how the local authority discharged the Section 117 aftercare duty? Would you agree?
I think the report highlights almost the overprescription of Section 117 aftercare, whereas other mechanisms could be utilised to provide support to individuals, particularly around continuing healthcare and funding through the Care Act. So it has highlighted that there is a lack of consistency as it stands at this time around Section 117.
Well, let's, before we deal with the bottom paragraph and go over the page, it's right, isn't it, that the review from the local authority has not identified any occasion during the period of time when VC became entitled to essentially unfunded packages of care after he'd had his Section 3 detention. There's no evidence whatsoever, would you agree, that anyone from the AMPS or from the local authority talked to VC or referenced Section 117 aftercare and VC's entitlement to it in the records?
I don't see any reference to that from the reports that have been provided.
Thank you. And one of the things that this review picked up on, would you agree, that if we go over the page, that the assessment documentation, top paragraph please, thank you, that essentially the authority didn't have specific templates for Section 117, and so this review essentially identified that people were almost using the Care Act framework rather than having a dedicated Section 117 aftercare framework which would meet and discharge the distinct statutory duty that the local authority has for free of charge without eligibility criteria or assessment.
That's correct, yes.
And so just picking up on Mr. Weston's questions, has that now been rectified, and does the local authority, adult social care, now have bespoke singular Section 117 aftercare documents for assessments of those entitled?
So the work we've been doing around with Section 117 with the ICB and our county colleagues, that policy will then support the changes that are required to be made around Section 117 documentation moving forward. So no, it hasn't been done at this time, but it will be done in the coming months as we move through our improvement plan within adult social care services. This rapid review was commissioned on the basis that we identify that there are areas for improvement. It also happened at the same time we did a peer review, so we are inviting external challenging because we recognise there is areas we absolutely need to improve on. That will form part of our further development around our new target operating model.
Okay, but you'd agree, wouldn't it, that this review found that the continued use of inappropriate templates may result in individuals being wrongly assessed, denied access to their entitlements, or directed into alternative service routes that are not appropriate. This introduced risks not only of unmet need, but also of legal challenge, financial liability and reputational damage for the local authority.
So I would agree that there's certainly a risk there, yes.
And certainly in terms of the Care Act framework being an inappropriate template for Section 117, would you agree that not only was there no evidence of VC under Section 117, as has already been identified, no evidence at any point that anyone considered the Care Act framework for VC either?
I would agree with that, absolutely. What I would say, though, is this was done in a period of time, sort of 3 years post our involvement with VC, so it's difficult to talk to whether this was what was in place 3 years ago. I can talk to this is what's obviously the rapid review found in the summer of last year. I'm not sure whether this relates to the period of time in which the team worked with VC.
Thank you. And I think also, just finally, it's right, as well as not having appropriate templates, the review also identified, I don't know whether it's on this page, it could just be expanded. I don't know whether we're still on. Thank you. We could go over the page, please. I think it also identified that the local authority, there was an absence of a Section 117 register. So even for those that qualified, there's not a register. And has that been rectified? Does there now exist a Section 117 register?
We have a list of our Section 117, but it's not as a register as in its current format, but it will be moving forward.
And will that then mean that immediately on being aware that someone in the locality has been detained under Section 3, that they are automatically added to that Section 117 register?
It wouldn't, no, because it would be depending on whether Section 117 duty would be triggered on the basis of there being identified care and support needs.
But Section 117 aftercare is triggered automatically when someone's had Section 3. So would you agree that at least someone should be continually reviewing or assessing whether there is that need?
So the Section 117 register, from our perspective, would be those individuals we're providing ongoing funding for, because the threshold for care and support has been met under 117. It wouldn't be for anybody who had a treatment order under the mental health. That would be ultimately put onto that. It would be a register of the ones that we have an ongoing supporting responsibility to.
And then just briefly on Section 117 and accommodation, it's right, isn't it, for mental health individuals who's been repeatedly detained on Section 3, that also engages the need for specialist accommodation to be commissioned by the local authority?
Again, it's absolutely dependent on the individual at the time and the assessment, what their care and support needs are assessed as and what would be most appropriate. I couldn't say for VC's case of what would be most appropriate for him.
Thank you.
Thank you very much.
Thank you. Yes, Mr. Stroh. Anyone from the council? Mr. McNamara.
Mr. Atherton, one of the last questions you were asked by Ms Cartwright on behalf of the survivors was in relation to Section 117. If a person is successfully treated in hospital, would you expect to be involved in the provision of aftercare?
That would depend on the identified care and support needs for the individual coming out and whether there was an ongoing requirement for support to be in place. It will vary from individual to individual depending on their ongoing presenting needs, also whether there is something additional other than just their mental health need that needs support with. Obviously, having looked at some of the information related to VC, the requirement for admission or readmission seemed to be for his non-concordance with his medication at the time, which sits obviously from a health perspective. But obviously, if somebody in that position is well and treated and has ongoing support around their medication, then there may not necessarily be any involvement for adult social care.
I understand. I appreciate it doesn't fit with the facts here, but theoretically, in the event that someone is treated successfully and they're discharged from hospital, even if they're detained under Section 3, it wouldn't automatically mean that there would be a need for the provision of aftercare.
No, that's correct.
you, forgive me, working backwards through the questions, you responded in relation to, I think, Mr Weston's questions in particular about multi-agency involvement, and you made reference to various agencies such as MAPA and the like. Building on that, what happens in the event that somebody isn't already, for example, known to the criminal justice system? What would you do in those circumstances?
Can you give a bit more context
yes,
to the question,
forgive me.
please?
So MAPA obviously depends on, but we're talking about public protection in the event that somebody already has a criminal record.
Yep, that's correct.
Or they have been discharged, for example, from a hospital order with various provisions put in place by the MOJ. If you were confronted with somebody in relation to whom there was nothing of that by way of history,
Yep.
so here on the face of it, there's no established criminal record, what provision would you put in place for multi-agency involvement?
It would depend on the presenting need of the individual. It would depend on what other organisations and agencies were involved. What we would look to do is bringing together agencies for discussions in relation to that particular individual and that particular presentation. So the ability to have multi-agency meetings isn't defined just by the sort of formal ones we have in place. They should be accessed by the professionals involved, working with the individual to provide the best possible care for that person moving forward.
Thank you. You've been asked a number of questions about care needs, and in particular when Section 42 is triggered. And it was suggested, for example, that in relation to Feven, the young woman who was injured when she leapt to safety, clearly she had to have hospital treatment and quite serious care and treatment as a result of that. But she was also the victim of a crime. Does the local authority investigate the care needs of all victims of violent crime who sustain physical injury?
We do not know.
Are you customarily told about the needs of all victims of violent crime who sustain physical injury?
We are not, no.
Absent some sort of surveillance of the healthcare system or the criminal justice system, how would you discover that somebody required the input of the local authority for the purposes of Section 42?
We would, if something had occurred, there would be the referral process that would need to come into adult social care from, well, that safeguarding concern could be raised by any number of partners or public.
Thank you very much. Those are all my questions.
Thank you. Right, I have no questions. So we'll break now and we'll take the morning break and we'll come back at 11:30. Thank you.
Chair, may I please call Rosanna Crane?
Yes.
Please repeat after me. I do solemnly, sincerely and truly, declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. Please be seated.
Thank you. Yes.
Ms Crane, you have provided a witness statement for the inquiry dated 13th of November 2025.
Yes, I have.
I understand there's a correction you'd like to make to that statement, is that right?
That's correct.
And what is the correction?
The correction is in paragraph 91, and it's referencing the telephone call that I have with Ellie from the university after the assessment. And in the statement, it says, Ellie stated VC's accommodation was at risk, and that should say Ellie had said that he could not return to his accommodation. Okay. So my response to everything after then is responding to Ellie saying he could not return to his accommodation.
Okay, so it's essentially a firmer position than here. It wasn't at risk, he couldn't return to it.
Yeah, Ellie had said the placement was at risk prior to the assessment.
Right. Subject to that correction, can you confirm the contents of your statement are true to the best of your knowledge and belief?
Yes, I can.
Briefly, by way of background, you are a social worker by training. Is that right?
I have social worker training, yeah.
And then you qualified as an approved mental health professional in October 2021.
That is correct.
And it was in that role that you participated in a Mental Health Act assessment of VC on the 19th of January 2022.
That is correct.
You'd therefore only been in the role for some 3 or 4 months by that point. Is that right?
Yes.
And I think you say you'd done no more than 20 or so assessments.
That's what I suspect it to have been around, yes.
Given your limited practical experience, do you feel your training as an AMP had sufficiently equipped you for the assessment on the 19th of January?
Yes, I was qualified as an AMP on the 19th of January.
The inquiry has already heard evidence from Dr Manzar and Dr Skelton, who were the 2 doctors attending the assessment, and they've addressed a lot of the decision-making, the rationale, etc. already. So I'm not going to go through every issue with you. I just have a few short topics to ask you about. If we can firstly turn to the referral, which is NOCC 5062. We can see there that the referral for the assessment was made by Miss Abby Parsonage, who we've heard evidence from on the 18th of January 2022.
Yes.
And you say your colleague, Miss Bagtas, had already done some of the work on the referral on that day, including obtaining the warrant.
That's correct.
And so then you then picked up the referral on the 19th of January.
Correct, when a place of safety was available.
If we just see there the reason for contact, Mental Health Act assessment request, flat tenants have contacted the mental health team due to having concerns as an incident happened last night, resulting in VC assaulting one of them. All other tenants have been removed from himself as hostile and has missed 5 appointments. So it's clear there that the incident is being described in the referral as an assault.
Yes, that is correct.
VC is being described as hostile, and it also says there that he's missed 5 appointments.
Yes,
right?
Yes, that is correct.
If we then just turn to the Nottingham City Council case notes, NOCC 5034 and page 7, would you have reviewed these notes before or when you became involved and picked up the referral on the 19th?
Yes, I would have.
We can see their note at the top of the page entered by your colleague Ms Bagtas, which provides some further information, which is that VC is showing relapse of psychosis, increased aggression, disengagement, and that an incident occurred where he assaulted his flatmates and trapped them in the room. Police were called, but no further action and no injuries sustained. Can you see that?
Yes, I can see that.
Was there any doubt, therefore, in your mind that the incident triggering this assessment was a serious assault?
There was no doubt this was a serious assault, a serious incident.
Nonetheless, did you consider contacting the police to get more information on the assault?
I had these case notes and I had the information used for the warrant application. I didn't contact the police when I was arranging the warrant about the assault. We had some conversations prior to execution about their notes and risk history, but we didn't discuss this assault.
Okay, so you had conversations with officers when executing the warrant?
Just prior.
Just prior to executing the warrant, but not about the incident immediately precipitating the assessment?
Not more detail than what I had in these notes and the warrant application about the assault.
Would it have been helpful to try and find some further information on what has happened from the police?
I believe more information about anything relating to VC history and leading up to the assessment is helpful.
Why didn't you seek that information from the police?
I was working with headline information from this document and the warrant application. I didn't seek the information specifically, and ordinarily I don't have high confidence that it would have been available. However, I didn't explore that myself.
Why do you say you wouldn't have had confidence that wouldn't have been available?
Within the timeframes that I was working towards to go from being allocated the assessment and completing the assessment.
Okay, so simply practically the amount of time you had.
A time limitation.
Would there have been any other barriers to you obtaining further information or seeking further information from the police?
Largely, I feel that the time limitation would be the barrier in getting the information from the people that had it within the police.
And so is it essentially the case that in the circumstances you felt you had sufficient information to conduct the assessment?
It's usual to use headline information. We have a summary of the assault, the police attendance and the outcome, and that was the information we used for the assessment.
If we turn to your report, which is NOCC 5040, you'll see the front page. So if we just go to the front page just to familiarise yourself, we can see the date of the referral, date of the assessment, and your name as the AMP there. Can you see that?
Yes, I can see that.
If we turn to page 4, we have a note of your telephone call with Celeste VC's mother. And it says there that Celeste advised that she was not aware of any issues with VC's mental health. That's not a positive statement. There were no issues, is it?
What I'm trying to say with this sentence was that VC's mother was not communicating concerns about VC's mental health at around the time of when she reports of speaking to him. I do believe she's aware that he has mental health difficulties.
Forgive me. So what I'm asking is, did you interpret this as her saying that VC was well, or as her saying that she wasn't aware of any not aware of any issues with his health at that point?
I believe I talk about this in my statement that at this time, VC's mother was not raising any concerns about things that she had heard or spoken to him about recently about relapsing with his mental health. That didn't mean to me that they couldn't be there. I think in my statement I say that they don't live in the same property, so it may be easier for the picture of how she understands it to maybe be different from how it actually is.
And as well as them not living together, you understood that VC had withdrawn his consent for her to be kept involved and updated as to his care, is that right?
Yes, I did.
And I think you also said in your statement you suspected that VC may not have been fully open with her.
Yes, I put that in my statement.
And you note here that Celeste was frustrated about not being more involved in VC's care, is that right?
Yes, I've put that there.
And ultimately her view was that she had no objection to admission if that's what the professionals thought was required.
That's correct, and that would have been relevant if we were pursuing a Section 3 admission.
Thank you. If we then look just further down the page, we can see the note of your call with, that's Ellie Turner at Nottingham University. What did she tell you?
Ellie advised me that VC, I'm just reading the note here, so I don't know if I'm
Take your time
meant
to
to say
read
something
it.
in addition, but in large, it was that there had been the incident of assault at the property and that the police were called, and that students were temporarily relocated out of the flat. Ellie had concerns about VC's mental health as being a risk indicator of aggression and how that could impact the other students. And I advised Ellie when I introduced myself that I was the AMP that was going to be doing a Mental Health Act assessment on that day.
And I think you say that you were not told during that conversation that VC was going to be unable to return to his accommodation, or that that was a possibility. Is that right?
No, I wasn't. My working knowledge at that time was that there was temporary safeguards in place and that there was still a sense of worry about risk, but it wasn't that he could not be there or that day or after the assessment.
Did you not ask that question proactively yourself?
It would be usual for such a salient point within the context of me being an AMP to do a Mental Health Act assessment. And I'm not sure if Ellie worked with the AMP service or she knew the AMP service, but I have a sense that she knows our team, and I can't tell you exactly how I know that, so I'm sorry if that feels speculative. But I think she believes she understood what I was there to do, so something so salient like that when we're talking about the plan would usually be furnished to me quite immediately.
So you relied on her to say that rather than asking about whether there are any accommodation issues yourself?
She's saying that the placement is at risk. She's worried about him being there, but we're not talking about an instance of he can't be there.
Okay. Turning to the execution of the warrant, I think you say in your statement that when you arrived, VC was sleepy, perhaps a little surprised, but there was nothing particularly unusual you found about his presentation. Is that right?
That's what I wrote down at the time.
And you say VC cooperated in being taken to the Cassidy suite.
He went with police and EMAS staff, yes.
If we can just turn to your witness statement, WITN 0177001, page 20, and it's paragraph 62 I want to look at first. You say that VC did respond to questions. If we can just display paragraph 62 and 63. Thank you. You say VC did engage in a two-way dialogue. However, his answers were just about, at the bottom of that paragraph, just about on topic, but evasive and superficial. Can you see that?
Yes, I can see that.
And then paragraph 63, that his delivery was monotonal and flat. And then you say that you got the impression, it's the last sentence, penultimate sentence of that paragraph, that he knew what to say and what not to say. What do you mean by that?
What I mean is it felt that we were leading the questions and then he would consider his answer and to say something back. So it didn't feel like he was offering up lots of information. So that impression gives me as saying the minimal amount of information needed to progress the assessment. And I also felt that when we got to topics of medication concordance, risk, and hospital admission, he would steer his answers towards what he felt was the right thing to say to minimise or present those things as less risky.
Is what you're describing there VC knowing what to say in order to avoid being detained?
I did get the impression that he did not want to be detained to hospital during that assessment.
It sounds like you're describing a capacity or propensity to manipulate. Is that fair?
I'm describing somebody who doesn't want to go to hospital and is filtering the information that he's sharing. I understand why you're using the word manipulate, but it's not the word I'm using. It might be persuasion or selective information.
Were you concerned by that?
Yes, when you're not completely confident in the information that you're getting, it will increase uncertainty in the decision making and the information that you've got to support the decision making.
Did you make those concerns that you had clear to Dr. Skelton and Dr. Manzar?
Yes, and I believe this was a mutual feeling within the assessment, and when there were opportunities to present other evidence to VC in the interview, myself, Dr. Skelton, Dr. Manzar were doing that in the moment as well.
If we just go back to your AMP report, NOCC 40 and page 5, in the big chunk of text, which is in the middle of the page there, you note that VC describes the events with the flatmate as being an altercation between housemates regarding the rota for the bathroom cleaning. Can you see that?
Yes, I can see that.
And then if we go to page 7, this is where you're setting out the rationale for the decision. You note again that VC stated the altercation with the flatmate was a normal interaction between peers over household tasks. Was it your view that this was a normal interaction between peers over household tasks?
No, this is just putting what his account was regarding how he had explained the incident of assault.
Was it concerning that VC was describing a serious assault as a normal interaction?
Yes, it is concerning, and it felt for myself, and I believe for the assessing team, that he was minimising the incident of assault, and that... One sec, I'll just leave the sentence there because it's gone.
Okay. So your view is this was obviously a serious assault.
Yes.
And I think you say in your statement that you also considered it to be an incident that related to VC's mental health.
Yes, and thank you. You've just sort of refound me on what I was trying to say. It was about his response not being proportionate, that we could anchor ourselves into being confident and being able to put that forward, because regardless of what he may discuss as the cause, that's not a proportionate response to what he was describing.
It had also been reported to you that VC had disengaged from his community mental health team. Is that right?
Yes, that's correct.
And we can see on page 4 of your report the note of your call with Miss Parsonage that VC had missed 5 appointments and last collected his medication on the 17th of December 2021. You note on page 5 of your report that VC said that he was taking his medication as prescribed, but that he'd essentially misunderstood the doses. Is that
Correct.
right? Did you consider that to be a likely explanation?
It wasn't possible to be correct, and we did not consider it to be likely. And it was helpful that we had been provided with, and we could work out that he would have run out, because we were able to put that forward to him, that he would have run out if he was taking his medication, which was the first account that he gave, and then changed the account after being told he would have run out.
So it was clear that he wasn't concordant at this point?
I don't know if it was clear. What was clear was that he hadn't been taking it as prescribed.
Is that not the same thing? Forgive me.
Yes, I suppose where I've understood it differently is if he'd taken any. That's what I was trying to respond to.
It's a question of a total non-concordance or partial concordance, but not full concordance.
It could not be full concordance.
I asked you questions earlier about whether you thought VC was manipulating or attempting to manipulate. Did you therefore think that VC wasn't being truthful about this point?
It was a probability that he could be not being honest about his medication concordance in the assessment.
And again, did you make your view on that clear to Dr. Skelton and Dr. Manzar?
I believe that this was a working knowledge between us, and we had discussed prior and after about the risk around medication non-concordance.
Turning to the decision itself, why was VC not detained?
VC, the assessment itself, it was difficult to discuss in terms of the legal criteria for detention, that the outcome of least restrictive option was a hospital detention under the Mental Health Act. Therefore, we couldn't detain him. And for my decision as an independent decision with no medical recommendations, I was then not making an application for detention.
If I can just turn to a couple of paragraphs in your witness statements. First of all, paragraph 88 on page 28. You say there, I remember Dr. Skelton was clear in his view that VC could be discharged to the community and supported by the crisis team, and that he then started writing up prescriptions as soon as the discussion was over. Paragraph 90 at the bottom of that page, you say Dr. Skelton was comfortable to own the risks associated with this, i.e. the community treatment plan, from the perspective of the crisis team. And then over the page, if we just go down a little, you say, middle of that paragraph there, Dr. Skelton had an influential perspective and I trusted the judgment of the doctors. It was after our professionals' discussion that I held the view that I was comfortable in applying the least restrictive option of community treatment. You say that you were comfortable with that plan after the discussion. What was your view going into that discussion?
So I hadn't made a decision or an assessment within that assessment around the treatment in the community, because it's not something that is my focus from a crisis team perspective. And I feel that before going into the assessment, it felt quite high that he would be detained, just generally looking backwards at the history.
So you don't know the details of the crisis team and what they can provide because that's not your role?
To this detail, and that's not what I was focused on in the assessment. That is what I would be deferring for the input from. If it wasn't from Dr. Skelton on this occasion, it would likely be another practitioner from the crisis team. I don't confidently say they definitely can do this particular treatment plan.
And you repeat again, we don't need to turn to it, paragraph 96, you repeat twice more that Dr. Skelton was comfortable to own the risk or take ownership of the risk of that plan. Were you persuaded by Dr. Skelton effectively that this was an appropriate plan?
It's not persuaded because I wasn't saying that it wasn't and he was saying that it is. Dr. Skelton's input is to inform me about the appropriateness of this plan. If I had something that felt quite stark, I could challenge that, but I'm not leading the appropriateness of that plan within that team. So persuaded is a difficult word, but he is influential because he is able to put that plan forward and to own that plan. So I'm influenced by that position, but I wasn't persuaded.
Okay. But you went into the conversation thinking it was quite a high chance that VC was going to be detained until Dr. Skelton gave further information on what the community treatment plan could look like.
No, I mean, I went into the Mental Health Act assessment with that feeling.
Okay.
Not the professionals' discussion. then I believe I used wording of it was feeling balanced.
Right.
So
Just briefly, if we can look at paragraph 84 in your statement, you say, this is, sorry, page 27, paragraph 84. You say it's important that the plan was about treatment. This was not an assessment for the purpose of assessing his condition. This was about treatment because we already knew what his diagnosis was. By that, do you mean that this was really a choice between no detention or Section 3?
it felt that this assessment, because we weren't detaining, we didn't get into the conversation as a group around Section 3. My view was looking at a recent discharge, and I'd spoken to Mum to make sure that if we were looking at Section 3, which felt very much on the table, for want of a better phrase, that was a possibility, so that it was about treatment.
Yes, so you're faced with what seems to be a relapse of a known condition, recent admission. It's a question of whether admission is necessary to treat that condition. As you say here, it's not about assessing the condition.
So we didn't go into that conversation as a assessing team around what's happened between discharge to now, what's typical, is there anything that feels different? So that would have come afterwards, but it was very much on the table, a Section 3 assessment.
You had some administrative involvement in the assessment a week later, just over a week later, on the 28th of January. Are you able to say from that involvement whether it's likely the assessment there would have been the same choice, i.e. looking really at Section 3 or no detention, or you're not able to comment on that?
We didn't discuss it in the assessment that I was a part of, and I wouldn't want to speculate.
If we can go back to your AMP report, I just briefly want to look at the risk summary. It's page 7 of the report, NOCC 5040. You assessed the risk to others as medium likelihood. Why was that? Sorry,
So,
you can see it there on the page now.
Yes, I can see this. So this risk assessment has identified a risk to others. This is looking at the historical information and then the incident of assault. And the severity of that is that it's highly severe for that risk to occur. The medium likelihood rating is given after the assessment, and this is considering the safeguards in place agreed between the university accommodation, uni and police at the time, closer supervision in the community from the crisis team, and supervised medication concordance, which links VC being treated and well to be reducing this risk. But I'm not saying that VC is treated and well at that time, but it's about having that plan in place.
Yes.
To make it immediate.
So if he was treated and well, the risk would be medium?
So at that time I've put it as medium because that plan is in place. So it's my thinking at the time was that those measures or that plan that was in place had reduced the risk around safeguarding and increased supervision and supervised treatment as a plan.
So when you talk about mitigations and provisions, are you talking about VC's flatmates being relocated?
Yes, the
If
safeguarding.
they hadn't been relocated, would the risk be high?
Like, possibly, I think there'd have to be more exploring with VC, with the flatmates, about how they felt, and that wasn't something that I had done at the time to see if that was going to be high. I didn't do that.
Did you understand the risk to be uniquely posed to those that VC lived with?
Yes, or lived around.
Well, quite, because here it says there's a risk, particularly those who live in close proximity, such as neighbours and flatmates. The flatmates may have been moved, but wherever he is, he's going to have neighbours, he's going to have other people in close proximity, isn't he?
Yes, that's correct.
So that mitigation measure only addresses the risk to a certain number of individuals. It doesn't address the risk to others in proximity with the VC or indeed the wider public.
Correct, and I do understand the point that you're making. So we've got the incident of assault that has taken place and the safeguards for that immediate environment inside of the flat. There's a bit of time that passes with from the incident to executing the warrant where we don't see further, and it's not to say that means everything's resolved, and then we've got the closer monitoring. So it's not eliminated, and risk assessment is difficult, and it's not you can't fully predict, but it was looking at those things together and seeing if that felt proportionate, and it can be dynamic and respond to further information, further evidence.
Forgive me, so part of the reason for the medium likelihood is the fact that the flatmates have been moved, which addresses the risk to them but not to others. Is that right?
In part, that
The other aspect of the plan is the treatment plan that's been put in place, closer supervision. Is that right?
Supervision and supervised treatment.
Yes. But that, of course, relies on that plan working, VC complying with it. Yes?
Yes.
And also it's not going to immediately reduce the risk because there will be time for that treatment to take effect.
That's correct.
Bearing those points in mind and his history of violence and aggression, on reflection, do you think that risk should have been assessed as high?
It's high. It can have high, and the reasons that I'd put medium, because the severity absolutely is high.
Yes.
And it was the likelihood that was felt to be a medium because of those things that have been put in place.
Just and on reflection, going through those issues, do you think the likelihood should also have been high?
So in this particular incident with the flatmates, it was with the flatmates, and we didn't have any thing to indicate further delusions that would be a bit more generalised. I do understand that the cause was more interpersonal within that flat rather than something that linked VC's aggression to the public at large for this particular incident. So I do understand what you're saying. However, this is how I'd understood it at the time, to be medium.
Okay, just moving on to after the assessment, you then speak again with Miss Turner. Is that right? The
Yes,
university?
that's correct.
And it's in that conversation that, well, tell us what she says about VC's accommodation in that conversation.
Ellie shares that he can't return back to the placement. That was the sentence, maybe not word for word, but to that effect.
And you say that that information felt to you like a tipping point, is that right?
It felt in that moment, yes, as a tipping point. If there's no accommodation for a community treatment plan, it would undermine the successfulness and then thus increase the risk more widely, including risk to the public at large.
Yes. But at that point, Dr. Manzar had already left, I think, is that right?
That's correct.
But you spoke to Dr. Skelton.
Yes, we were still...
What was his response?
So we agreed that I would provide this additional information to VC because we hadn't shared that in the assessment, and that might impact his decision around informal admission. And then I passed the telephone to Dr. Skelton because I didn't want to Ellie's phone call to be terminated. It wasn't finished at that point, but I didn't want to miss the opportunity to speak to VC.
And so VC then refused a informal admission that you put to him,
That's correct.
and so the decision was made to carry on with the plan that had already been discussed before this information came to light.
So the decision was already made prior to the conversation with VC, and VC declined informal admission again, even in light of the new information.
But there was nothing you could do to revisit your decision, one, because you require supportive medical opinion, which wasn't available to you. Dr. Manzar had left, and Dr. Skelton, it didn't cause him to revisit his view on the appropriateness of the plan, did it?
So we have concluded that assessment prior to speaking to Ellie. VC has been discharged. So what I could do, it would be starting a new process. So when I've gone back to the Cassidy suite, I'm informed the placement, he can return to the placement is at risk, which is as I had understood it to be at the beginning of the assessment.
Just finally, you set out a number of reflections and recommendations at the end of your statement. The first is that an assertive outreach capability would be of benefit in cases such as VC's. And in particular, you say that might have the effect of reducing the need for Mental Health Act assessments. Can you just expand briefly on that?
So I understand that there used to be assertive outreach functions in this trust where I work. I don't work, I work alongside, and they have more resource and smaller caseloads to work with more challenging people to engage.
I'm not talking about just specifically what benefit the team might have been for VC's treatment, but the specific point on the interrelation between that and demand on the AMP service. You say that an assertive outreach team or function you think might reduce the need for Mental Health Act assessments. Is that right? We can turn to it if we need to.
Can I see it? Just so
yes, it's the final page of your witness statement. Page 34.
Yes. Okay, thank you.
And the end of paragraph 102, if there was a mechanism and more capacity by which teams could be more assertive, I suspect that there would be fewer requests for Mental Health Act assessments. I was just trying to understand why that,
thank you.
that would be.
So I suspect there would be fewer Mental Health Act assessments. I'm speculating. If you've got an assertive engagement function, which the crisis team do offer. It's not to say that there isn't one there. The crisis team offer it. That's going to be with, I believe, your sort of long-term care team, so there's less sort of transition, and I do think that that's beneficial for keeping people well for longer.
Yes, so is it that if there was a more assertive team, there would be less disengagement and therefore less need for Mental Health Act assessments that arise because of someone disengaging from their community team? Is that the short causal relationship between the two?
So I'm saying that if people are kept well for longer and supported within their team and have that resource and capacity and function, that would in turn result in possibly fewer Mental Health Act assessments.
So if one was considering the resources required for an assertive outreach team, one point to put on the other side of the scales might be potential impact on the council and the AMP service.
I'm not really thinking about the council resourcing. I'm more just thinking about people staying well for longer and not requiring mental health act assessments.
I'm grateful. Chair, those are my questions.
Okay. Yes, Mr Maloney.
Very few, Ms. Craig. If I could ask you about the circumstances of VC's second refusal of an informal admission. So that you offered him an informal admission to start with and that was refused, but then you spoke to Ellie Turner and you offered him a second informal admission, or there was a second offer made of informal admission.
Yes.
Can you just describe what was said between you and where that was when you had that conversation with VC?
So I had left the custody suite because I understood he had been discharged, and came round to find where he was waiting for a taxi, which was near to the car park.
Yeah.
And I informed him that I had spoken with the uni and been told that he couldn't go back to the accommodation, and that this wasn't information that we'd shared in the assessment, and therefore there's still the option and off bed if he wants to come in as an informal patient.
Yeah.
And he said, I don't want to be an informal patient. And I said a bit more along the lines of, if you haven't got anywhere to stay, it's probably a good idea, you know, when you're informal, you can. Talked a bit about the difference in restrictions.
Yeah.
And he said something along the lines of, I will resolve the accommodation issue.
Yeah. So that he would solve that accommodation issue, yeah. Can I just ask, finally, when you assessed VC, you knew he'd reacted to a situation in a violent way with his flatmates, and you've described that this morning to the chair as not proportionate to the situation, was the feeling that you got about it.
Correct.
Yeah. And you knew he was not fully concordant with medication.
Correct.
And he was minimising his behaviour.
We felt that he was minimising for sure.
Yeah. And you knew from his history that he couldn't be relied on to comply with medication.
I understand that there have been times that he stopped his medication.
Yeah. Whilst telling people that he was taking medication.
I can't recall what I've specifically read about him saying he has when he hasn't historically. I know that that was what occurred in my assessment.
Right, thank you, Ms. Crane. There's just this, on reflection now, and it's obviously it's very difficult with hindsight, you know, you can speak with hindsight, but would you now have detained at that first assessment, given all of that you knew?
In terms of...
Given all of those circumstances, should you have detained at that point?
So those circumstances are important and relevant.
Yeah.
It was about the criteria, and I don't believe that those circumstances can make the criteria be met.
Yeah.
It was about the interview, and it was about the presentation and the assessment of the doctors around mental disorder, degree, nature, that it felt we were stuck on in that particular assessment.
All right, thank you, Ms. Crane.
Thank you.
Thank you. Yes, Ms. Cartwright.
It's just one question. Just when you told us about that, you then were aware that VC had lost his accommodation. Did you know that he'd had a detention under Section 3, so had an entitlement under Section 117 for the assistance of the local authority to help him find specialist accommodation?
Yes, I did know he's been detained under Section 3.
But did you tell VC that he could get help with accommodation? And it would be free if he met the criteria?
I didn't discuss 117 in that conversation. When I returned after the conversation I had with him, I understood that he was not homeless. If that had been different, I feel that in terms of exploring possible options, 117 accommodation would have been something to consider at that time, because it was important to his mental health and important to the plan and the decision that had just been made.
Okay. And then can I just ask you on accommodation, one other provision, there's a rehabilitation unit called Bracken House, is that correct, that's available that can help with rehabilitation, people with mental health problems, but also to support with education. Were you aware of Bracken House Rehabilitation Unit and whether that was an option to raise with VC at that time also, that you could look to see if they had a place for him?
It's not something that I had come to me on the day. I've heard of Bracken House as a placement for people.
Right.
I don't know about the rehabilitation side of it. I've not got a lot of knowledge on Bracken House.
Okay. Thank you very much indeed.
Thank you. Yes, Mrs. Straw.
Ms Crane, I represent VC's family. Could we have document NOCC 5040 on screen, please? Page 4. This is your report from 19th January, and you referred to a section earlier about it. It's at the top of the page. It's about the telephone conversation you had with Celeste Callacane on the 19th of January 2022. The first line was read out, and it goes on. Celeste advised that she had spoke to VC the day before. He had asked if she was okay. That was it. Celeste advised he stated he is taking his medication, as well as stating he was seeing the doctor next week. Celeste advised she was frustrated about often not being involved in VC's care, often only ever receiving a call when there was a Mental Health Act assessment. Celeste feels hopeless in VC's care, however, acknowledging that VC has said that she can't talk with professionals, so that is why they do not ring. Celeste advised that she accepts if VC needs to go to hospital, stating that what needs to be done should be done. Just a few questions about that, please. Firstly, is it right you were aware that Celeste wasn't receiving information from professionals about VC at that point?
Yes, I was aware that phone calls to VC's mum were often limited to Mental Health Act assessments. I can see that there's a record around them being in Mental Health Act assessments.
And she wasn't involved in his care at that point?
I didn't have any information to say that she was providing any care, but it sounds and is being said to me that they're having telephone calls.
And you note that she spoke to VC. She spoke by phone. She wasn't seeing him face to face, was she?
We didn't talk about her seeing him face to face. I know that they'd been speaking by phone. I didn't ask if they were seeing each other face to face.
Were you aware that psychiatrists indicated that seeing VC face to face was important because he was someone that masked his symptoms?
When did they say that?
It was significantly earlier, but were you aware of that at all?
Generally, it would be better and more than better to see people face to face to understand their mental health and just general circumstances. We have to do that as part of the Mental Health Act, so that would suggest that it's helpful.
And you note here that Celeste understood VC was taking his medication at that point. You were aware he wasn't taking it, weren't you?
I've been informed that he would have run out of medication by now if he was fully concordant.
So would you agree it appeared he was hiding things from Celeste?
That was what I had taken from this conversation against the Mental Health Act assessment and other information I had.
And thank you. And then could we please move on to Ms Crane's witness statement? So it's WITN 0177 001 and page 15. Thank you. In the bottom of paragraph 48, you continue on this topic. So you say, I also sense she, Celeste, was despairing because VC would not let her be involved. I did not conclude that VC was likely well as a result of the conversation, however, could be well enough to mask his symptoms when speaking to his mum. In summary of all of this, was it your view she wasn't really in a position, because of all those factors, to make an informed judgment about his mental state?
I wasn't looking for an informed judgment around mental state, and I do consider that her availability of seeing him and maybe having a judgment might be impaired by, or would be impaired by, the distance and the even distance around his care and his support needs that he had put in place with his mother.
Yeah. Thank you. And finally, just a different topic, in paragraph 41 of your statement, if we could just look at that, please, it's page 12. You referred to some information you received from Abbey Parsonage, and you say this, so the references to VC being paranoid, angry and confrontational, I think that came from Miss Parsonage, recorded in the contacts are important. The significance of this information is that VC was probably unwell. Can you explain, please, why you considered that VC was probably unwell?
So when I read that, or was provided that information on the telephone call, that was the significance I've taken from that information from Abbey at face value. And that would be because these presentations seem to be linked to his relapse indicators around his mental health. Paranoid specifically, and then angry, linking it to agitation.
Okay, thank you very much.
Mr. McMurray.
Just a couple of questions, please, Ms. Crane.
Yeah.
You were asked about a place called Bracken House. Are you familiar with it?
I've heard of that as a placement where people sometimes are, if I've worked on a case, a duty system, and that would be probably like a residential type placement, which would indicate residential or above level of support, but I don't know what it is.
Do you know who runs it?
Who what's it?
Do you know who runs it?
No.
So would it be news to you if it was run by the trust, for example, rather than by the local authority?
Those two things are relevant on that particular time.
And would it be news to you, for example, to discover that it's usually for residential mental health care for those who are already known to mental health services?
That's evidence, isn't it? She doesn't know anything about it.
Very well. Thank you. No more questions.
Okay, thank you.
Yes, Ms. Patry, I missed you out.
Thank you, Chair. Ms. Crane, I ask questions on behalf of the University of Nottingham. 3 short topics. Before I ask my questions, can we situate ourselves in time? Your involvement was on the 19th of January. The day before, VC's flatmates had been moved out of the flat that he shared with them. So the evidence that's been given is that they had taken a few belongings, but they were always going to return because they had exams. Were you aware of that?
I was aware of a delay around the place of safety. I don't know if that put the incident a couple of days before my assessment. So there's a delay around place of safety, there's getting the warrant, there's getting the referral to us. So I was aware that the flatmates had been relocated as a result of the incident. But if it was the day before, then that means they might have been in there with VC directly after the incident for a few days, and I didn't know that.
All right. If we could turn to your report, NOCC 00040, we can see what you're told about that. It's page 4 of that document. Can you see about halfway down the page, telephone call with Ellie Uni mental health team? You can see there, Ellie advised that there were risks regarding Valdo being at his property waiting for an assessment. Ellie advised the other students were not at the property, however this was temporary as they need to be back home so they can study for exams. So, and she wanted an update. So can we be clear, when you first spoke to Miss Turner, she told you that this was a temporary arrangement, didn't she?
Yes, it was a temporary arrangement.
And that they needed to come back to the flat so they could study for exams.
It was temporary, and yes, they need to be back where they live to study for exams. Yes, she said that, and I did understand that at the time.
I'm really grateful. Can we turn on in this document to the bottom of page 5, please? Again, discussion with Ellie Uni mental health, right at the bottom of that, and then over onto page 6, ambiguity re his residence there. Can we see where it says in the second line on page 6, Dr. Skelton provided some input to Ellie advising that community plan is the least restrictive option. However, he would require home in order to do this. And then right at the end, it was emphasised that stability for Valdo was important to the community plan being successful. Do you recall that conversation?
So I'm not present when this conversation is happening. This is my summary of when the conversation is fed back to me, and then sort of a bottom line on how the status of accommodation stability is left.
All right. But do you accept or do you agree that by offering alternative accommodation to his flatmates on a temporary basis, this was the most flexible option to allow for stability for VC during this period prior to the Mental Health Act assessment?
The offer of alternative accommodation and that safeguard was very flexible for those that offered it and those that cooperated with it, the flatmates, in VC's benefit and in the safety of them.
But you accept it was also for VC's benefit, kept him stable, meant he stayed in the flat, he didn't have to move, and you kept him stable pending the Mental Health Act assessment. You agree?
So I was never informed that this arrangement was just into the lead up of a Mental Health Act assessment.
All right. Can I ask you, my second topic is this, can I ask you to turn to page 15 of your witness statement, WITN 0177001, page 15, paragraph 49, please. Do you see that it refers to the GP, but then about halfway down the paragraph, the university may also have insights from tutors. No additional information in this view was shared from Ellie, so I worked with the assumption there was no further information to explore. I don't know if you heard the evidence Mr. Atherton earlier this morning. He seemed to accept that AMPS should be proactively seeking information from education establishments such as the university. Did you seek any information from Ms. Turner or anyone else relating to what the tutors might think about all of this?
I didn't ask about the tutor's impression of his mental health. I don't think I'd ask about mental health, but I'd accept if they shared things, but I wouldn't be looking for their opinion on his mental health. But around his studies isn't something that I sought. And for the purpose of the assessment, it doesn't link directly to the criteria that we're assessing.
You seem in this paragraph to be criticising Ms. Turner for not having provided additional information. Do you accept that it is your responsibility to ensure that you proactively seek and acquire salient information?
I have a responsibility to seek information, and it's not a criticism, it was just a statement of fact that there wasn't information shared.
Thank you very much. And then finally, I want to ask you about what happened after the Mental Health Act Act assessment had taken place. You corrected paragraph 91 of your statement this morning to say that Ms Turner told you that VC could not come back to the accommodation.
Yes.
Right, now, are you sure about that?
So he's being discharged, and I'm passing on the information of the assessment and then the outcome, and that would mean that he was being discharged home, is how the conversation starts. And then she says that he couldn't go back to his accommodation, which is what I'm respond to in that moment, because we were aware that the placement was at risk, was shared before, and we were working with that. It's at risk. There's not scope for anything to be further occurring, is essentially what I'm understanding before, but after, it was that we're discharging him to somewhere he can't go.
Is it possible, Ms Crane, that you misunderstood the position? The only reason I say that is he was in the accommodation when you came to conduct the Mental Health Act assessment. He went back to the accommodation and remained there until February, right?
Yeah.
Ms Turner has no power to evict him from non-university accommodation. Is it possible that you misunderstood?
So we were talking, the further information was, I think it's in a case note that I write directly after the conversation around unfit grounds to study and something else. There was 2 phrases that I'd taken from the conversation with Ellie after. I'm not going to rule out any possible miscommunication. However, looking at how I've responded quite quickly and urgently to my perceived, happy to use that word, change in accommodation status, and the information that I then relay to VC to say, it's quite possible you can't go back, or you can't go back, we're on these lines, and it was a few years ago, that reaction was to new information, or what I had understood and felt was new information.
But again, can we agree it was your responsibility to find out what the accommodation position was for VC after the Mental Health Act assessment had taken place?
I would have, it's the conversations before, because afterwards it's less helpful to find out things afterwards.
It is, which is why you should have asked the question.
Before?
Yeah.
So before, when I'd spoken with Ellie, I'd understood that he was in accommodation and that the status was a temporary plan around the students and VC. It wasn't about this plan is until this particular time, like the assessment, or it wasn't about this plan isn't working and cannot continue. So they would indicate a risk of homelessness, but I got that information after the assessment.
All right. Thank you very much. Those are my questions. Thank you, Chair.
Yes, I just wanted to ask a couple of questions, Ms Crane. Just turning to that page, I think it's NOCC, it's your report, 5040 at page 7. Do you have that? I think it'll
Not
come
at the
up in a
minute,
moment.
it's coming.
Just looking at that and the risks, the 2 with high severity are further decline in mental health and the risk to others who, physical and verbal risk to members of the community who live in close proximity. Do you agree with that? The others are medium severity.
Yes, I can see it now. It's highlighted. Sorry, I'm just seeing what's
Yes, you can see those 2
similar
are the high risks. You understood that the students had been temporarily moved out, and in fact, because for their safety.
Correct.
So this plan could only work if they stayed out, couldn't it?
The immediate safeguarding relied on the temporary relocating of the students.
And what is put in risks, other risks, that he was unable to complete his academic studies, and you've also put stigmatisation from peers. Did you balance that against the fact that you were told that they had to complete their studies as well?
It's a very fair point that the impact of
moving them out
and the incident and everything that was occurring would also be impacting the peers' academic studies, which could have been captured in the other box that doesn't say if it's self or others.
No. And as far as least restrictive option, that's not of itself the criteria, is it? It has to be consistent with the risks and safety.
So when I'm looking at the least restrictive option, I'm thinking about the Act and the decision. I do accept that that as a response to a flatmate is highly impacting on the flatmates.
Yes. All right, thank you. We'll now take a 5-minute break and then we'll come back. Thank you.
Please stand. Chair, may I call Helen Foster, please?
Yes.
Please stand. Please repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
Please sit down. Ms Foster, you gave a statement to the inquiry dated the 12th of February 2026. Can you confirm the contents are true and accurate as far as you're concerned?
Yes.
And you tell us in that statement that you qualified as a nurse in 2000 and you were a charge nurse at the Priory Hospital between March 2018 and August 2022. Is that right?
Correct, yeah.
And you stopped nursing in February 2024.
Yes.
We asked you about your interactions with VC whilst he was at the Priory Hospital, and you tell us at paragraph 9, it's hard to recall VC as a patient because I never even had a conversation with him. You do recollect some matters. What do you recollect generally about him? I'm going to take you to the nursing notes in due course. We'll go through some of them.
He was very isolative, stayed a lot in his bedroom, hardly ever saw him. Never had a conversation with him. They just wandered out, in and out of his bedroom when he was on the ward. Otherwise, he'd be out in the community somewhere. So I didn't really have anything to do with him, really.
And what was your role on the ward and your job when you were...
My job, staff nurse, just giving out medication, assessing patients' needs, organising the shift as to who was doing what on the shift, you know, if there's any sort of escorts out, arranging staff to go with people, speaking to people on a one-to-one basis, you know, as a named nurse for different patients.
But he wasn't your...
He wasn't mine, no, he wasn't mine.
Can we just go to some documents then, please? So it's paragraph 25, page 11. As I said, Ms Foster, we know most of these are not yours, but let's just go through those so that we have a sense when he left the Signet what was happening in the Priory. So if we go, please, to page 11, we see there, this is the risk assessment completed by a doctor at the Priory. We know that from the page over leaf 12. We don't need to go to that. But if we look at what the risk management plan was, we see here if it's possible to enlarge the first 6 items. And if we look as well at the beginning, full physical health screening on admission, including physical examination and blood tests. Do blood tests involve using needles?
Yes.
If we look, please, at number 2, given current presentation, require a minimum of 4 intermittent nursing observations within an hour. We see restricted access to items at 3 that he could use to harm himself. So it goes without saying that he wouldn't have weapons or implements that could cause self-harm or harm to others. And we see at 6, encouraged to work with the psychology team who will offer input by way of one-to-one as well as group sessions. So that's documented as the plan at the beginning. Would nurses routinely look at the plan, or would you write your own notes?
Well, if I was the person actually admitting a patient, I would go through all the different parts of that assessment process. So it would be his history, his family, physical needs, health needs, if he's on any medication. It would be absolutely everything. and that would be done in, at the side of the admitting doctor.
Well, let's have a look what was done, in fact. So Pagra 25, page 9. We see here the new admission. This is, in fact, completed by the doctor, I think. Title, new admission. Do you see under the medical at the bottom? If we have that box enlarged, please. What we see here, Ms Foster, is a description as follows. Line 3 of that top box. His admission was preceded by an episode of psychosis. He recounts hearing male and female voices in his head, telling him someone is being raped next door. This made him act by barging into his neighbour's apartment, thereby causing them distress. There was associated history of violence and aggression. He had had to be de-escalated by police officers who he assaulted in the process. Tasers and gas had to be used to keep him under control. Reading that, would you have thought that was describing a single event or different events factually? Or wouldn't you know?
Maybe a single event at that point, but it's very risky behaviour.
Mm-hmm. Risky behaviour, and factually, if you were to deduce from that one event when the police were called and he heard voices relating to a rape, factually incorrect, because we know there was more than one event. So that wouldn't make it clear to you that there were 3 or 4 events.
No, not really.
Within
That's just talking about that particular incident.
Right, so you take that as one incident.
Yeah.
If we look at the paragraph above, please, the nursing notes at the top of the box. Again, it repeats in the admission on the day note, 5 paragraphs down. Sorry, 5 lines down. VC spoke, I had got into an altercation with hospital staff at his home. He thought that someone was being raped in his neighbours' homes. Amidst these thoughts he was having at the time appeared to be a symptom of illness. So again, would you think the hearing someone being raped and getting into an altercation with hospital staff was the same event, or would you think it was different events, or wouldn't you know?
From that, I sort of deduced that there's been previous events that's happened.
Mm-hmm. But would you consider them carefully explained or described or factually clear from these summaries?
No.
If we go, please, to Pagra, same document, page 8. We see in the box at the bottom of page 8, the 2nd of October, right at the very bottom, VC's property has been placed on his property list. So just to be clear, we know he's accompanied by 2 staff in an ambulance to the Priory. The property list, what's the role of the property list? What happens when a patient comes in?
The property list, anything the patient brings in, that is clothing, any toiletries, anything at all. That we actually search through everything. You have to write it all down on a property list, and then it has to be transferred onto the, the documentation system as to what they've got and everything, and check with them. Anything that we thought was a risk, we check for drugs and weapons and anything. It should be written down.
So these are properties they're able to have on the ward, as it were, or with them.
Yep.
Items that you're not concerned about. It's the bottom line, can you see?
Bottom line.
Yeah. So VC's property has been placed on his property list. So there's a documentation of what patients have. Yeah. And it looks as though that happened here.
Yeah.
If we go 2 boxes up, please, to the 3rd of October, we see he's fast asleep during the night drug round. Hence, he missed his night medication of haloperidol. So he's prescribed, presumably, medication he should be taking at night, and he's asleep and doesn't have it. Is that typical at the Priory, or would you wake someone up and make sure they had it, or wouldn't you like to comment on that?
I would wake him up, really. I think it's quite important, looking at his history and things. I think it's quite a risky thing to miss, really. I mean, I'm not sure how long, obviously, I'm not a doctor. No. I'm not sure how long, but I don't think it's a good idea for somebody with his history to not take prescribed medication. He could have been woken.
Did that happen much, that you'd wake patients to give it or not?
I would personally. But
I
don't think that other nurses did actually wake patients until they were asleep. They just probably omit it. Maybe they tried, but I don't know in this instance.
Was that at the Priory or generally in your nursing experience?
The Priory.
Right. You didn't think that people did wake people up?
No.
There. Was that different from your experience nursing in other environments?
Yes. Yes.
Can we look, please, at the entry at 5:15, 2 boxes up?
Yeah.
You see, VC was in bed at the start of the shift, maintained a low profile, remained in his bed space the rest of the shift, took his medication, though he did not attend the clinic when he was prompted, but when the nurse took it down to his bedroom, he accepted. So the system for taking medication, did you encourage patients to go to collect the medication at the clinic, to actively engage
Yeah, we
with
did.
that?
I mean, we didn't just take it down to the patient. You know, that's that particular nurse who took it to him. But yes, we did encourage people to get up. Well, obviously, you can't assess somebody if they're in a bedroom. You can't see mental state or anything. You can't assess anything about a patient if they're just in the bedroom taking medication. We don't know what's going on, really. So I prefer it then to come out and take it.
4th of October above, keeping well, spent the shift mainly in his room, accessed the lounge and communal area but remained mainly in his room, attended ward round and was able to communicate that he no longer heard voices and he hoped to be discharged soon. Discharge to Beacon Lodge was discussed and VC was keen on this option. You weren't party to this conversation, but do you know what Beacon Lodge was? Or?
Beacon Lodge was like a place which was, people would go there, and it was like, most like supported living area. I don't think there were like many restrictions on things, but a lot of people used to come to the Priory and then actually go to Beacon Lodge before being discharged either back home or into the community or wherever they came from before.
Because they had some support there, did they?
Yeah, yeah.
And we see VC is recorded as being keen on this option, and this was 3 days after his admission to the Priory. If we can go to PAGRA page 7, please. We see the entry at the bottom of that, page 7.
Yeah.
At the very bottom, 639. VC was polite upon interactions on a needs-led basis. And if we can have a document while I ask you about needs-led basis, please, on the screen. This is an extract of a witness statement from Dr. Aziri, Priory Healthcare, WITN 0229001, page 39, please. It's page 39, paragraph 153.
Yeah.
And we see Dr. Aziri says engaging on a needs-led basis means the patient interacts with staff or services only when they perceive an immediate or practical need, rather than engaging consistently in ongoing treatment or recovery work. Such patients may approach staff for specific requests, medication, meals, discharge, discussions, but otherwise remain withdrawn or avoid therapeutic interaction. Would you agree with that description of needs-led basis?
Yes.
If that can go down, please, and we go back to PAGRA 25, page 7. And it was the bottom entry at 6:39 a.m. where that is mentioned.
Yeah.
And you say that fits with your impression that he wasn't around and in the communal areas and generally engaging.
No, he wasn't. I mean, he was saying what he wanted people to hear. You know, about when he went to, the Beacon Lodge after 3 days after admission. Not going to say I'm hearing voices because he wanted to leave, wanted to go.
And is that typical nursing patients? You need to be alert to that kind of...
You certainly do, because, I wonder why people are saying these things. That there's, it's only from, experience and knowing the patient, and we didn't know him very well because he was very isolative. So we didn't really know what was going on with him.
If we go to the top of page 7, the entry at 1838, you see at the top, he has spent time in his bed space, isolating himself during the shift. He's had minimal interaction during the day and has been asleep at times in his bedroom. VC has attended for his medication and has attended for meals during the shift. He utilised his escorted community leave in the afternoon, and this appeared to have gone well. VC has his ward round this afternoon. It went fairly positively. He was granted unescorted grounds leave and he was prescribed aripiprazole. I'm not going to ask you about medications. The doctor giving evidence this afternoon about that. Granted unescorted grounds leave. What was that?
Unescorted grounds leave, I mean, on the 2 checks, So he was given, I mean, I don't know exactly what he got, but it meant that he could go out after having what he was wearing on, you know, where he was going, what time he went out, what time he came back, and that would all be documented on a piece of paper and then signed by the nurse. If he's been given, and it would be unescorted ground leave, would be whatever the doctor thought was appropriate at that time.
And we see he's got escorted community leave at that time, so out in the community, not just in the grounds.
Unescorted grounds leave. Then.
Unescorted grounds,
sorry.
and two lines
that's
up.
Just in the that's just in the actual grounds.
In the grounds
themselves.
is unescorted, but outside is escorted at that point.
Right.
Looks like, doesn't it? It says he utilises escorted community leave in the afternoon. Is that different, going escorted into the community rather than
escorted community.
grounds?
Oh, yeah, that's it. That's right. Yeah, sorry. Escorted community leave, so he'd be with somebody going out in the community.
Yeah.
But he could go around the hospital grounds themselves unescorted.
Understood. If we go to page 6, please, of the records, and the second from the bottom, the box at 1941, under keeping connected, his mum called today inquiring about him in his university course and wanted to know what can be done to help. Was it typical if nurses took calls to record it in the records with families?
Yes.
And what's the importance, where there is a next of kin, of those conversations with families?
Well,
how does that help?
The family know the patient better than we do. You get a lot of information, you know, when patients are admitted to the hospital, you get a lot of information from them about how they really are, you know, and sometimes information that they don't disclose when it's being assessed.
And we see at 7:04, as you've described in your statement, keeping well, VC mainly bedroom-based, came out the lounge area on occasion. If we go further up, on the 10th of October, there's an entry, and this one is by you, to say there have been no issues regarding his safety. He remains on level 2 times 2 checks per minute. VC had brought some belongings in when he went on community leave, presumably sometimes between the 7th and the 10th, and it says VC brought a hammer in his rucksack, unclear as to whether he picked this up by accident or whether it was intentional. When did you discover that he had a hammer in his rucksack?
I cannot recall the person who actually brought him, you know, when he came from his leave, who reported it to me. I can't remember the name of the person who actually told me about that, what he did, whether it, you know, he filled in an incident report form about it, which obviously it's really serious. So I just can't remember the person who said, because obviously that should have definitely been recorded, and he should have had his leave stopped immediately.
Well, you recorded it here. Is that because somebody had told you that? Did you see the hammer yourself?
No.
So this was what you had been told?
Yeah.
By somebody who...
And to be honest, I can't remember if I saw the hammer or not. I just can't remember, because it's such a long time ago.
Yours appears to be the only note about it. So the person who told you, what was their capacity? A nurse or someone checked property items?
I think it was a support worker, a male support worker.
So did support workers check what people bring back in?
Definitely, yeah, you have to do, because obviously people can bring anything in. They bring drugs and all sorts of things in, so
is there a proper search when they come back?
A proper search. I mean, an actual physical search as well, because it's unescorted, especially because he'd not been there very long.
Yeah.
So it should be a physical rub-down search and then checking through all what is brought in.
And would that support worker ask questions about why he had it or not?
Well, I would hope so, yeah, because it's a hammer, so definitely.
Did you have a conversation with anybody about what VC had said at the time about having that hammer?
No, I can't remember having a conversation about it.
But to be clear, he didn't have a hammer, unlikely on the property list when he first came from Signet, did he?
No.
So here he is on the 10th with a hammer.
Yeah.
Clearly that's a potential weapon, isn't it?
Absolutely, yeah.
So you recognise it was serious, but you don't remember now how that was followed up?
I don't know. I assume, obviously, he would have gone, when he's on his unescorted leave, he's gone and brought this back. So I don't know what his thinking was. I'm bringing that in.
Can we go to Pagra page 5, please? The 11th of the 10th, the 3:47
Right.
entry. Keeping well, VC was in the lounge area, has not observed having any conversations with staff or other patients, has been awake at times in his bedroom on checks. At keeping connected, VC not observed to have made any external contact with family or friends. Looks as though is that your entry, can you see, Helen Foster? Was that confirmed by you as the senior nurse?
Yeah.
So 03:47, so it's likely in the night time then, he's in the lounge area, is that right?
Yeah.
So up at night. Is that right?
Yes, it will.
Not observed to have any conversations with everybody and awake when he's in his bedroom. So he's already awake at night now. Is that clear from that? Is that what it looks like? It's night. It's in the night that he's in the lounge area, presumably by himself with not other patients in the night. Do people normally go to bed at night?
There might have been other patients out, but I don't know at that time. Sometimes there are patients who are unsettled and not...
move around.
Yeah.
If we go, please, to the penultimate box at the top, 07:21 in the morning.
Yeah.
This is on the 13th. He requested to be escorted to the vending machine where he bought himself a drink of pop, came back and stayed in his room throughout the night, appeared to have not slept at all throughout the night, but spent the night on his laptop. No management issues encountered, though. VC had no night medication. So awake all night with no night medication, again, can be pursued with a doctor, but if he was due to have medication, he should have had medication, shouldn't he?
Yes, certainly.
And if he wasn't due to have medication, it didn't look like he was getting into a routine of being awake in the day and sleeping at the night, which is worrying, isn't it?
Yeah.
Why is that worrying?
Because it shows that his mental state is probably declining if he isn't taking the medication as prescribed. I mean, I don't know whether he was on the one, you know, it was changed to aripiprazole, wasn't it? And I don't know if he was the one previously, the haloperidol. So obviously, it's not helpful to his mental state that he isn't taking that medication.
Or getting sleep, by the
Or
looks
getting
of it.
any sleep, because that's going to just make his mental health deteriorate even more. You know, he's going to become more paranoid.
Were you able to monitor sites visited by patients or activities online if they're up at night and they're on a computer or anything else? Did they have any way of monitoring what
people... Not really, no. I mean, I'm assuming he used because we had a computer in there and where they could watch whatever they wanted. But there wouldn't be any reason that's been raised by anybody to say monitoring what this guy's actually watching.
So computer, would it be his own computer or hospital?
It would be, there was a hospital computer, there was a computer room there.
So you can check a search history on a computer normally, can't you? Did you ever do that?
I know, I wouldn't know how to do it.
You wouldn't know how to do it. Was that ever discussed generally on the ward, if they were using a ward computer, checking in what people might have looked at?
No, it wasn't general sort of...
And it's not something you had any training about, asking people about, what have you been looking at, anything's disturbed you, or just introducing it in some form of conversation?
No.
Can we have a look, please, at the top, 1657. A colleague, a staff nurse, had a one session with VC this afternoon. He expressed he's settled and well. His medication, particularly the aripiprazole, is better than the one he had in the past, as it gives him no side effects. Second paragraph, we discussed his current accommodation issues. BC explained he was in a shared accommodation and the suggestion about Bracken House seems plausible. However, he indicated he was also looking for accommodation on his own. So on the 13th of October, so that's 3 days after he'd been found in possession of a hammer, he was clear he was looking for accommodation. He didn't have accommodation. He wasn't settling himself into accommodation. There was nowhere he was hammering nails up or getting a place ready for accommodation. Can we look at Pagra 25, page 4, please? 14th of October at 7:07. It's clear from this entry, VC's not prescribed any nighttime medication, returned to bed. VC has appeared to have slept well during the night, no further concerns to report. The box above at 540 remains on level 2, 1 check an hour. What's level 2?
Level 2 is just 1 check an hour. There's like level 1 where you'll have somebody, you know, different levels, let's say 1 check an hour. So it basically means that in 1 hour, the person with like a clipboard will have all the different patients or different levels of observation, and we'll just check that person once per hour. You know, there's some where people are one-to-one observations, where there's somebody with them all the time, 24 hours a day, and there's like one check an hour, 2 checks an hour, 3 checks an hour, 4 checks an hour.
And what are you
5
checking for?
Checks. Checking their well-being, making sure that they are safe in the bedroom and what they're actually doing as well. You have to record what a person is doing. If they're sat there, you know, if they're watching TV, if they're just reading or anything.
Yeah, we see the paragraph, the entry above on the 15th of 10th. Spent his time in his bed space using his laptop.
Right.
Completing some drawings, requested a ruler from staff. If we go, please, to page 3 in the notes. Again, we see the third entry from the top, 7:36 in the morning on the 18th.
Yep.
A VC was already in his bedroom using his computer at the commencement of the shift, continued to be isolative and withdrawn, pleasant on approach but giving closed answers. VC visible in the lounge during supper. He attended for supper, engaged briefly with staff. VC spent time on his computer in his bed space and remained low profile. Stayed awake on his computer till around midnight. So an extensive amount of time on the computer.
Yeah.
Page 2, please. The bottom entry. VC's presentation in mood and mental state continues to present as settled, still maintains a very low profile on the ward, throughout the shift being solemnly bedroom-based, pleasant upon interaction, no difficulty approaching staff on a need-led basis. So by the 18th of October, the same reference to the need-led basis rather than actively engaging and proactively involved in therapeutic discussions or the like. Is that fair?
Yeah.
If we go, please, to the third box from the top on the 20th of October, we see a reference, keeping healthy, concordant with prescribed medication. VC attended the clinic this morning and reported he'd fallen over. He had a cut to the bridge of his nose. He didn't allude as to how this had happened, but accepted a plaster. We see no description anywhere of a fall or the injury to the bridge of his nose. Was that common, that you'd noticed something like that and you couldn't describe or explain how
it should have been documented. That definitely should have been documented. They should have had a body map. They should have had a documented it. Should be documented incidents, what happened. Just giving a plaster isn't really adequate.
And also the cause, what in fact actually happened to cause that.
Yeah, definitely.
Injury.
That should be recorded.
We see, and it does look as though, at least on the chronology of it, the community leave to the city centre follows, I think, if you look at those entries, in order to sign up for an engineering course at the University of Nottingham. So the majority of the day is spent out of the hospital perimeter.
Yeah.
VC returned to the ward around 15:30 this afternoon, invited to attend the community meeting, though he declined and stated he was busy. The entry is actually made at 7:01. Can you deduce from that whether the injuries happened before the community leave or after or not?
I mean, possibly before he came back from his leave, but I don't know what happened when he was out where he got injured.
It would be important to know, wouldn't it, if that had happened in the community? Really important.
Well, if there's no sort of supporting evidence or documentation to say what happened, you just don't know.
We see at the top of this, 10:44 a.m., Claudia Birtles is asking, as his care coordinator, information about the outcome of his ward round. VC is planned to be discharged tomorrow. So if we go to page 1, please. Note at the bottom, 1920, VC maintained a low profile on the ward, being mainly bedroom-based, continues to actively approach staff on a need-led basis, has minimal engagement with other peers on the ward. If we look at the entry above at 750, in his bed space at the start of the night shift, later was in the lounge area using his mobile phone for some time, remained low profile, minimal engagement. And then we see the entry above, VC discharged to his new flat, given 14 days aripiprazole. He was asking a friend to drive his car to the flat and no psychotic features noticed. Do you agree, as per your statement and going through the records, it's clear that he remained isolated and spent a lot of time in his room during the time he was there?
Yes, I do.
He also spent a considerable amount of time on his phone and his laptop.
Yeah.
Whether it was university work or what he was looking at. Did anyone ever ask him, looking at the notes?
I don't think so, no.
Doesn't look like he engaged with any therapeutic activities on the ward in accordance with the plan.
Well, all he just, like I say, needs-led basis was just what he wanted, whether he wanted to drink, whether he wanted to go out, whatever. But no engagement, not in my view. Not as a nurse, definitely not.
And there were no instances... There were instances, when he did not proactively attend for his medication.
Yes.
It had to be taken to him, and there were instances where he missed his medication or night medication. In terms of the hammer incident, having a hammer in his possession, that doesn't look like that was followed up at all.
I don't think it was, no.
And if we look, please, at PAGRA 83, page 1, the incident management reporting system that was policy in place at the Priory, defines at page 2. An incident is an event that's caused or has the potential to cause harm. 1.3, all colleagues have a responsibility to ensure all measures are in place to prevent the likelihood of such incidents. Would have been important to find out the basis upon which he had that hammer, wouldn't it?
Definitely.
If we go, please, to 4.1, which is page 4 of the policy. All incidents and near misses must be concisely recorded on a data incident reporting system. Yeah. Did you think of doing that? You were told about it. Should you have put that on the data system?
It's because the person, if he reported it to me, actually I don't know if I was nurse in charge, but the person making me aware of that should have filled in a datex.
Did you say to them, you can't remember now, fill in a datex? They didn't anyway, did they?
Well, they didn't do it, obviously, but it should have been done. Because obviously, how the Priory operates is that a lot of staff, our bank staff, a lot of staff don't know how to record incidents, and it's better coming from the person who actually got the hammer, who actually spoke to him, because we didn't know how he got it or anything. And obviously if it's not recorded, it didn't happen, because it has to be recorded.
Page 6 of the document, para 4.15, successful incident notification is depending on a comprehensive knowledge of the facts surrounding the event. So as you say, it should have been identified when he got hold of it, why it was with him, and what that represented.
Absolutely, because obviously if we don't record things, people are just completely unaware of it, and it's a really serious thing.
And that's the point about incidents, isn't it? There might not be a particular harm or immediate impact, but it's what they represent, and it's important for risk.
What's going on. Yeah.
There was a CQC report in respect of the Priory Arnold, CQC M0016484, page 1, please. Inspection on 15th of June 2021, publication of report 22nd of July. If we go to page 2, we see third lines down, staff did not always assess and manage risks to patients and themselves well. We highlight that.
Yep.
And then we see leaders did not always demonstrate they had the skills to perform their roles and ensure the patients of patients and staff. If we go, please, to page 5, penultimate paragraph of the first box. Before this inspection, received information of concern from anonymous contacts and from a relative about incidents that happened on the wards and the management of patient risks. Do you see that? Should be highlighted 2 paragraphs above the how we carried out this inspection. It's that
Is it the 70?
2 lines.
Yes.
No, it's not that box. It's 2 lines above the how we carried out this inspection.
Oh, yeah, I've got that.
We'll go further down the page again, page 5. Do you see before this inspection? There we are.
Yes.
Received information of concern from anonymous contacts about incidents that happened and the management of patient risk. We see over the page areas for improvement. Page 6, the provider must ensure, the last point, audits and government systems fully assess and identify risk to patients and staff, and improvements are made as a result. Page 9, please. Again, records showed, the last paragraph, that staff completed risk assessments for each patient on admission and reviewed this regularly. However, before inspection, we were informed of an incident where a patient self-harm showed staff did not manage well the risks to the patient. Were you aware of any steps taken between June, July 2021 and when you left, I think in October 2021, to improve staff's training on risk assessment and risk management? Did you have any such training?
We had some training, but the Priory Hospital tends to have a bit of a knee-jerk reaction to incidents, and they don't follow up a lot of things. They don't follow up incident reports, you know, sort of like support for staff after an incident's happened, and that's quite commonplace. I mean, I worked there for 4 years, and I can only remember one occasion where somebody came down and discussed an incident and like the way forward and things like that. I just don't think they do what they say they're going to do. I've always felt that there.
Can we have, please, NHNB 0014406, page 1? The overall rating was inadequate, whether the services were safe, inadequate. Was that discussed with you as staff, that it was ranked as inadequate and what needed to be done?
It was discussed, but it's always been a sort of a blame culture, where it's our fault we're not doing certain things, and then impose loads of paperwork, loads of documentation. You've got to fill this in, you've got to fill that in, which we were running really busy wards. There were really vulnerable patients, what we're looking at, very high risk. And then it introduced a load of things like, oh, you've got to clean down every hour, you've got to do this every hour. That have like things where, oh, you must record everything all the time. And all this adds to the number of jobs that you've got to do as a nurse and all the other staff that's working with me. So, sorry, I forgot the question now.
How many doctors were there working there, roughly?
There's usually one consultant psychiatrist for each ward. I mean, at the time, I think there was only 2 wards open because the other 2 had been closed, and so we didn't admit anybody. But there was only like 2 actual consultant psychiatrists. Then you'd have a ward doctor, which was, he probably would come down and do the actual assessments when they were admitted. But
who were the consultants at the time you were?
Consultant, it was Dr. Guru Singh, what's his name now?
Dr. Guru Singh.
That's him, Dr. Guru Singh, I think, at the time, yeah.
Those are my questions, Chair.
Yes, thank you. Yes, Mr. Maloney.
Ms Foster, if I may, just very briefly, please. You spoke essentially of a view of VC of not really engaging on the ward. And where patients are isolated in situations like that, is your view that direct questions need to be asked of them rather than making assumptions?
Absolutely.
Yeah.
You can't assess anybody if you don't speak to them. I mean, as a former nurse, I would have gone into the actual bedroom and sat with them and asked them things, specific questions. The people that don't want, you know, why did you do this? Well, what's going on in your head? try to sort of get an insight into what's actually happening. You can't just assume anything in nursing. You certainly can't, because people are very, very poorly, a lot of them, and they won't talk to you because they've got all these thoughts in their head. And it's your duty as a nurse to go in there and actually find out what is going on. He should never have been left just to his own devices and nobody bothered engaging, just assuming that he was all right, because obviously he wasn't all right.
And when you're face to face, can you get a better sense of what they're actually saying and whether they
Certainly
mean
you
it?
can. Yeah, you certainly can, because some people will not come out the bedrooms. I mean, I've had patients where you've had to go in and started speaking to them about different things, but you have got to ask those questions that nobody else dare, because you can't possibly have an assessment of a patient's mental state if you don't talk to them, you know, on a one-to-one basis.
Can I ask you more generally, was there a limited focus at the Priory on engaging patients who were more isolated? Was there not a great deal of effort made to engage people who were more isolated?
No, there wasn't, not in my view, no.
And can I just very quickly ask you on the back of that, in terms of the training for most of the staff, was it mostly centred around containing physically destructive behaviours by patients rather than other more general things?
I think so, yeah. It wasn't as therapeutic as it should have been.
Yeah. Did you get the sense of whether there was much effort put into getting a sense of who each patient was and what their specific needs were to help them recover?
No.
No. All right. Thank you very much, Mr.
Thank you.
Yes, thank you. Right, well, I've got no questions, so we'll stop there. We'll start again at 20 past 2.
Thank you, Chair.
Thank you. Yes, Mr. Khan.
Chair, good afternoon. May I call, please, Dr. Ajith Gurusingh?
Please stand. Please repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much.
Thank you.
Sit down.
Yes.
Dr. Gurusingh, you have prepared 2 witness statements for this inquiry, haven't you?
That's correct, yes.
The first date is 7th of November 2025.
That's correct.
And the second dated 9th of December 2025.
That's correct.
Are those statements true to your best knowledge and belief?
Yes.
So far as your professional background, you're a consultant psychiatrist.
That's correct, yes.
And you work for the Priory Group.
That's correct.
And since 2020, you have been the medical director of Priory Arnold.
That's correct.
And that is the hospital, isn't it, that VC was transferred to from Signet, Psychiatric Intensive Care Unit, on 1st of October 2021.
That's correct, yes.
And during the admission at the Priory, you were VC's responsible clinician.
That's correct, yes.
For that part of the admission that was under section.
Yes.
And the overview so far as VC's time at Priory is concerned is he was transferred on the 1st of October on a Section 3 detention. The Section 3 detention was rescinded by you 2.5 weeks later on 18th of October 2021.
That's correct, yes.
And a few days later, 22nd of October 2021, he was discharged back into the community.
That's correct.
So a 3-week stay in total.
Yes.
And when discharged back into the community, it was with no CTO and no depot medication in place.
That's correct.
The reason why you have prepared 2 statements is because, one, you deal with your interactions with VC from your perspective as a doctor, and the other is looking at things more broadly in your position as medical director for the Priory.
That's correct.
Now, at the time of VC's admission, the Priory Arnold was on special measures, wasn't it, from the CQC?
That's correct.
And that is because of concerns that had been raised by the CQC on inspection of your hospital.
That's correct.
And if we can look at some of those concerns, please. First document, CQC M0016484. And if we go to page 9, please. And at the bottom of that page, we can see the risks being raised are that staff did not always assess and manage risk to patients well.
Yeah, I can see that, yes.
And the concern being described in that paragraph is essentially one as to inadequate approach to risk assessment.
Yeah, I suppose that implies that, yes.
And to be clear, this is following a visit. It was in June of 2021, wasn't it? So it was prior to VC's admission.
That's correct, yeah.
And if we turn to page 10, the next page of this document, we can see about 5 paragraphs down, the service did not have a good track record on safety. And the next paragraph, the service did not always manage patient safety incidents well.
Yeah, that's what the report states, yes.
And so again, concerns that go to the safety of the provision at your hospital. And then the final entry I'm going to go to in this document, next page, page 11, final paragraph on that page, ward teams did not have access to the information they needed to provide safe and effective care and did not use that information to good effect. So again, this is another point as to the safety of your hospital, isn't it?
That's correct.
And the particular point being raised here is in relation to obtaining necessary information and information sharing. Is that right?
I cannot make a comment on that. It does say it did not use that information to good effect. Maybe it's in reference to a particular incident?
Well, it doesn't seem to be referring, does it, to a specific incident. It's talking in general terms. Ward teams did not have access to the information they needed to provide safe and effective care and did not use that information to good effect. That appears, doesn't it, or it reads as a general comment.
Yes, I agree, yeah.
But in any event, you're the medical director. You would have received this report, and it would have been a cause of concern for you.
It was.
So how did you understand that paragraph?
So it was a comment on following their inspection, so that, was following evidence and observations. So I accepted that was a concern that was highlighted.
What steps did you take between receiving this feedback from the CQC as to the safety of your hospital and prior to VC's admission? Had any steps been taken prior to the 1st of October 2021 to correct these or address these concerns?
Yeah, I'm sure we have taken steps to address these concerns following each report, each recommendation. We are required to provide an action plan. I'm sure we have provided an action plan following this as well.
My question was specifically in respect to the period to 1st of October 2021, and what I'm asking essentially is what we read in this report, does this reflect the position on your unit at the time that VC was admitted, or had steps been taken prior to the 1st of October 2021 to address those concerns?
We I can't remember exact steps that we have taken, but surely following each review, we are required to provide an action plan. So that action plan would have been sent to the CQC.
Prior to the 1st of October?
I hope so, but I cannot really confirm. I don't have that information.
And quite apart from any action plan, these concerns raised by the CQC, they really ought to have been at the forefront of your mind and the mind of all the staff at Priory Arnold.
That's correct, yes.
In October 2021.
Correct.
If we can look, please, another document, WITN 01870001, and what's about to be put on screen. It's page 2, please. What's about to be put on, or what is on screen, rather. Dr. Guru Singh. This is a witness statement of Noel Prince. He is one of your employees, wasn't he, at Priory Arnold?
Yes, ex-employees, yes.
Ex-employee. And he has some interactions with VC. You can see what he says about that under the heading Interactions with VC, paragraph 6 to 8. But it is the entry under paragraph 9 that I want to look at, that I want you to look at. And halfway down that paragraph where he comments, in respect of the Priory, the focus of such an environment is simply to make sure that the patient is safe and alive, and no real effort is made to get a sense of who each patient is and what their specific needs are in order to help them recover. The training provided is mostly centred around containing physical destructive behaviours with minimal education to help recognise and understand psychological symptoms. Do you accept that that's a fair representation of treatment in Priory Arnold?
No, I wouldn't.
At October 2021?
No.
Which bits of it do you take issue with?
This particular person was an occupational therapy assistant, activity coordinator. I'm surprised that he's made this observation because it was part of his job role actually to interact with VC if that was the case.
Can we look, please, at the document CQC 0019689? And you see this is another CQC report. It's an inspection report following a visit, or visits rather, in December 2021. So it postdates the previous documents I took you to, and it postdates VC's admission, doesn't it?
Yes.
And you can see from page 1 that the rating, the overall rating for your hospital was inadequate. Do you see that?
Yes, I can.
And in respect of whether services were safe, again, it was inadequate.
That's correct.
And those previous entries I took you to in the last CQC document, they also went to the issue of safety, didn't they?
They have, yes.
And if we look within this report and go, please, to page 13, I'm not going to read it out in full, but you can see that towards the bottom half of the page there's a heading assessment of patient risk that has a paragraph underneath it, and then management of patient risk. And again, it's raising similar concerns to the previous report following the June visit as to the approach of your hospital to risk assessment. Dr. Guru Singh.
Yes, so, sorry, I was kind of focusing on the...
Oh, forgive me.
Yeah.
And page 15, please. Bottom of the page, track record on safety. The service did not have a good track record on safety. And then the final entry on this in this document, rather, page 16, at the top of the page under the heading Reporting Incidents and Learning from When Things Go Wrong. the service did not always manage patient safety incidents well. And it seems on reading through this document and comparing it to the previous one, it's the same criticisms, isn't it?
That's correct.
And so between those two documents, do they reflect the state of play as at the time that VC was admitted to Priory Arnold?
Well, obviously, I mean, the CQC did observe certain lapses. If I remember right, this report was completed following a death of a patient as an inpatient. So they were scrutinizing many things very closely, and they did identify certain lapses.
As a result of the inadequacies found by the CQC, the special measures that apply to you, or amongst the special measures that applied to your hospital, were that you were required to obtain the consent of the CQC before admitting a patient.
That's correct, yes.
And it required you to submit certain documents to the CQC in order to do so.
That's correct.
And there is a referral checklist amongst the Priory documents, and that's the document you would have sent to the CQC to obtain their consent.
That's correct, yes.
And VC was admitted. He was admitted to a ward in which all the patients were from the Nottinghamshire Healthcare Foundation Trust.
That's correct. We had a contract back then.
So you're effectively operating a whole ward on behalf of the
That's
trust.
correct, yes.
Now, in terms of documentation, when you are receiving a patient and the documentation that you have or should have available to you, the Priory had its own policy, didn't it, on admission and discharge. We can put that up. It's at Priory document 33. You see this policy, admission, transfer and discharge.
Yes.
If you turn to page 4 of this document, at number 3.8, it states the request should be made for medical records for any patient who has had previous inpatient treatment, especially details of potential risks and serious incidents.
That's correct, yeah.
So as a starting point, when you're receiving a patient, particularly one who has previously been admitted, the expectation and requirement is that you go and obtain their medical records.
That's correct, yes.
And that's for the purposes of obtaining as full a history as possible.
That's correct, yes.
And you've explained in your statement, the first witness statement, so the one ending 2001, it's page 5, top of that page. You've explained that, in fact, the Priory had read-only access to the Trust's electric patient record system.
Sorry, if you could repeat that question?
Yes, if you look on the screen,
yes.
You've explained in your statement that you had access to the RIA records,
That's
so
correct,
the
yes.
medical records held by the Trust, but that was read-only.
That's correct, yes.
And so did that mean that where you had a patient who was going to this ward that you operated on behalf of the Trust, you could log on and you could see the entirety of their RIA records?
Yeah. However, I'm not too sure whether I have a brief recollection of reading RIA notes, but this RIA access we had was on and off because sometimes with password issues you don't. But we had access to RIA notes whenever we wanted, so that wasn't an issue at all. So we could access.
Okay, so let's deal with that point. The procedure, the policy was, or the practice was that you had access to RIA records. You should have access to RIA records. And it may be that there were technical difficulties on occasion with passwords, but it wasn't a case of the Trust withholding access.
No, not at all, no.
And if you encountered a technical issue with any patient, then presumably you could pick up the phone to the trust and say,
oh yes,
sort this
yes,
out, we really
absolutely,
need to see
yes.
the records, our policy requires us to see
Yes.
the records, and you as a clinician would want to see the records.
That's correct.
And in respect of VC, was there any issue in accessing his RIO records so
No.
far as you recall? Did you read VC's RIO records?
I have a brief recollection of reading at some point, having access to some records that I was provided recently. I had a recollection that I might have read some of these information. They were familiar.
Sorry, say the last bit.
They were familiar. The records that I viewed recently, that was handed over to me recently over the weekend and recently.
When I refer to VC's RIO records, do you know what I'm talking about?
Yes.
My question is, when VC became your patient,
yes,
you had access to those RIO records.
Yes.
Did you read those RIO records when he was your patient?
I read some of it, yes.
And in terms of the responsibility to read records, is that one that's on you or you and the rest of the team?
Sorry, when you're referring to reading RIO records, are you asking me whether I have actually logged on and viewed the records?
How else would you read the records?
So sometimes they do provide RIO records printed. Sometimes they share records if you ask. So in this case, I remember reading, I have a recollection of reading through some of the RIO records.
Yes, but whether printed or
yes.
reading on screen,
yeah. Yes.
I think the point is you have access to
yes,
RIO records
yes.
for patients.
Yes.
You don't remember any difficulty accessing VC's RIO records, and your recollection is that you read them.
Yes.
I'm asking whether the responsibility for reading them, whether that's one that fell only on your shoulders or whether everybody in your team at the Priory would be reading or should be reading RIO records.
Well, not everyone had access to RIO. If I remember right, some of the ward admins, the Mental Health Act administrator, and some of the medics had access to RIO. Not everyone had access to RIO.
Who didn't have access to RIO?
Sorry?
Who did not have access to
Most
RIO?
of the staff did not have access to RIO. Only a handful of staff members had access to RIO. Few medics, few ward admins, and Mental Health Act administrator.
What was the rationale for that, do you know?
Because they did not give free access to everyone.
The trust didn't give free
Trust
access?
did not, no.
And so how did the system work? If you looked at RIO records and there was something in there that you thought it was important for the rest of your team to know, those who didn't have access, how would you go about communicating that with them?
Well, so we do have meetings on a regular basis. In the morning, we discuss patients during handover, and we discuss patients during MDT meetings. So if I have some information that I feel relevant for the rest of the team, I would let them know.
Was there any relevant information from VC's RIO records that you passed on to the rest of your team?
So we had adequate information already received at the time of the referral. I cannot really remember discussing anything further other than that.
So the answer is no?
Yes.
In respect of the RIO records, and we can put them up, please. It's NHFT 40168. And I'm going to go to a number of entries in this document in order to establish the information that was available to you and whether this accords with your understanding of the patient you had in your care. So we're on page 1 of this document, and you can see the very first entry on that page refers to VC kicking the door into another flat and being arrested, and this led to his first Mental Health Act assessment. And then if you turn to page 3 of the records, the entry in the towards the middle of the page, 24th of May, 9:13 p.m., we can see reference there to VC, and this is later on, trying to smash the door of another property, and the fact that the neighbour has jumped from a first floor window and is currently in the back of an ambulance complaining of lower back pain on the way to hospital. Now, just pausing there, did you understand from these records that on the 24th of May there'd been a Mental Health Act assessment, hadn't led to admission, a VC had returned home and then tried to
That's correct,
access another flat? Did you seek information, or were you aware of the injuries that had been suffered by VC's neighbour who had jumped from a window?
Yes.
You did? Where did you seek the information from?
Because we received it from the referral paperwork itself.
And what was your understanding of the injuries suffered?
Some back injury, serious form of back injury. That's my recollection, yeah.
And then if we go forward to page 11, this is during VC's first admission. This is a ward review, and presumably the ward reviews would be particularly important documents for you to consider, because that's where VC would be being reviewed by another consultant psychiatrist. And we can see under the heading MDT discussion a reference to VC saying, when asked what he was talking about, he said capital punishment. And that, for a psychiatrist, that would be a matter of concern, wouldn't it, if you have a psychotic patient who reports that they're having thoughts of capital punishment?
It would be a concern, yes.
And then page 17 of these records. This is another ward review during VC's first admission. In the middle of the page, under patient comments, it says, since people have been following him, watching him, probably since last October, a few lines down, did not feel fear but became angry about this. This is why he went to the neighbouring flat to try to get the people he thought were invading his mind. And again, was that an important piece of...
That is important, yes.
And why is that an important piece of information?
It's evidence that he was paranoid about other people interfering with his mind.
And acting on that paranoia?
Acting on that as well, yes.
And trying to get at the people he
That's
thinks...
correct, yes.
In a deluded sense?
It is delusion, yes.
At page 21, and again still in the first admission, this is an entry by Dr. Sedat, the consultant, one of the consultants on the ward VC was admitted to, and this is a summary by Dr. Sedat of text messages and phone communications that had been sent to him by VC's family. Did you see this?
I cannot remember everything, but I have, like, while I was reading notes recently, kind of reminded me that, oh, I've seen this some time back. So that's kind of recollection I have.
Do you think you saw the actual text messages? They've been provided
No,
to you?
no, I don't think, no, I haven't seen this.
Do you think they should have been provided to you, to the Priory?
Not necessarily. I mean, so they don't provide everything that's on Rio. It's really impossible. It's loads of information. But if they felt some of the information was relevant, they should have. So those text messages, of course, never seen that before. I have no recollection of seeing that.
But you've reviewed them for the purposes of giving. You've reviewed them for the purposes of giving your evidence today.
Yes.
And having reviewed them, they go further, don't they, than what is in the summary on the page in front of you on the screen?
Yes, I agree, yes.
They have entries, for instance, to VC stating, I think they are watching. I know that I can break their heads with my hands. A text message from VC, wanted to hurt permanently. And text from VC, I was thinking about red rum not 120 minutes ago. Would you know what that reference
Yes, I do, yes.
was? And those are significant entries, aren't they? Because they come straight from...
They are significant entries, and that's a classic representation of somebody who's suffering with a severe mental illness at the time.
And it indicates potentially, doesn't it, thoughts, pretty strongly, thoughts of harm to
Absolutely.
others.
Yes. I mean, the experiences he was going through, trying to understand the experience. So he was reporting back to people the experience. He was trying to explain his own experience to others. And that's quite normal. We see it all the time with patients when they for the first time when they go through such experiences. They're quite traumatic and they're quite confused, and they would try to understand what's going on.
So having seen those text messages for the purposes of your evidence, do you think that they don't contain any information that you weren't already aware of in respect to VC?
No, so I knew that he suffered from a severe mental illness. There was no doubt in my mind it was paranoid schizophrenia. And he was a classic case of a severe a person who's suffering with a severe form of paranoid schizophrenia. And that was, all these symptoms were part and parcel of his clinical features, his symptoms.
If we go in the records, please, to page 56, you were aware that VC had been admitted again to hospital shortly following his first admission.
That's correct, yes.
And were you aware of the circumstances as we see set out on this page, the entry of the 14th of July, VC banging on a door, forcing his way in, pushing past a resident, having to be restrained?
Yes.
And also within that entry, it's the third paragraph, there is a reference, isn't there, to the police finding unused medication strip.
Yes.
And that would indicate that VC was not concordant.
Yes, it could indicate he was not concordant, or at some point, or he had additional medication. Possibly he wasn't concordant fully.
Were you unclear about whether or not it was
No, it was clear to me that he might have been non-concordant at some points, but I could not conclude that he has not been concordant at all. That's what I mean.
Well, if you look at page 58 from the Mental Health Act assessment prior to that second admission, 4 lines down, clear from today's assessment, he decided to stop taking his medication 2 weeks after his discharge from hospital. Mm-hmm. So pretty clear, wasn't it, that he was non-concordant?
Yeah, it seems like that. Yes.
And so following a period where he had been admitted and released with medication, within a fortnight he stopped taking his medication.
Yes.
And that was an important factor, wasn't it? Or something that you ought to have heeded whilst you were caring for VC.
Yes.
And then page 138, and this is an appointment in the community with Dr. Burry. So Dr. Burry was a doctor. He was working under consultant Tahina Lloyd in the EIP team. This was an appointment from November 2020. And it's the second paragraph in particular that I want to take you to on this page. Second sentence, he, that's reference to VC, said that just before his discharge from admission at Highbury Hospital back in July, he told ward doctor that he no longer hear voices, but he said that is not the case, and he only said that because he was tired for being in the hospital. Now that's a significant entry, isn't it?
That is, yes.
But why is it a significant entry?
Because he could have well been lying or not being truthful about taking medications.
Well, isn't there significance to it in that VC is admitting here, having deceived, misled his treating doctors in order to get release from hospital?
Because, so he could basically mask his symptoms and pretend that he's not experiencing psychotic features in order to simply leave the hospital, get out of the hospital.
And this is an example of that?
Yes, that's correct, yes.
And that's a significant risk factor?
That is a significant risk factor, yes.
And then the final entry in the RIO records prior to you caring for him, page 167, and this is the note in the records by Dr. Leamas of the Mental Health Act assessment in September 2021. It would have been particularly important for you to consider this, wouldn't it? Because this
yes, indeed,
is
yes.
the assessment leading to the admission that you were concerned with. And if you look under the, in the middle of this page, under the heading Scene, can you see how 3 lines down, end of that line, it refers to VC being polite and calm?
Yes.
A few lines down, initially invited us into the property and we went with him. Next paragraph, he answered the door and remained polite. Politely repeated his assertion that he wasn't going anywhere. And then in the next paragraph onwards, the notes describe, don't they, a brutal and violent attack upon the police officer.
That's correct, yes.
And so is the key takeaway here that you have a patient who can go from presenting as polite and calm into extreme violence motivated by his illness or as a result of his illness?
Yes, it indicates he's capable of.
And we can put the records down for now, but do you accept that the picture that emerges of the patient that you had before you was of someone who, when unmedicated, became violent?
That's correct, yes.
Someone who could present as calm and polite before becoming extremely violent?
Yes.
Someone who lacked insight and so was at risk of becoming non-concordant?
I would agree, yes.
And someone who could mask and deceive those treating him in order to get out of hospital?
I agree, yes.
If we can look now at the documents dealing with VC's condition, immediately before he's, or shortly before he's transferred to the Priory, you received some documents from Signet, didn't you?
That's correct, yes.
The referral, and we'll look at a Priory document 6 first, and this is a Signet patient review from the 21st of September 2021. And if we go to page 3 of this document, you can see at the bottom of that page there is a description there of what Claudia, and Claudia was, that's the reference to Miss Birtles, VC's care coordinator, who is describing that since the last discharge, that's the discharge from the second admission, she didn't think VC had ever recovered, that his contact was superficial, and his compliance with medication questionable, hence depot has been considered.
Mm-hmm.
Now, did you consider this document?
I did see this document, yes.
You did?
Yes.
And so you were aware, were you, that the community team were considering or had considered depot medication.
I was aware, yes.
And then at page 4 of this document, we have the mental state examination at the top, carried out by Dr. Shodakova and her team. And you can see what it says in there about VC. I'm not going to read the whole thing, but it concludes, doesn't it, with a complete lack of insight by VC.
Yeah, so it shows lack of insight in certain areas, yes.
Well, it completely lacks insight is how the paragraph concludes.
Yeah, I would agree that it shows, I mean, I wouldn't say complete lack of insight unless, like, it's described widely, but I would agree that he did not have adequate insight, or his insight was very poor.
And this is a description of the patient. This is a little over a week, isn't it, before he was admitted to the Priory? That's correct. And in addition, you were also sent from the same date, the 21st of September, a copy of a Signet risk assessment, and that's Priory document 3. If we turn to page 2 of this document, we can see risk of harm to others is marked moderate, and risk of non-compliance with medication is also marked moderate. Did you understand that this risk assessment tool was assessing VC's risk whilst he was on the psychiatric intensive care unit and was limited to an assessment of the risks on that unit?
Yes.
It wasn't an assessment of risk, was it, of VC once off the unit or whilst in the community?
It's current risk, so it's during the admission period.
Now, both of those documents are from the 21st of September. The Signet running records that you obtained on the referral only ran to the 23rd of September. Was it not important to obtain from Signet the assessments, running records, patient reviews for the entirety of VC's admission to the intensive care unit?
The MDT reviews sort of summarized or captured his presentation throughout his admission, and it all indicated that he didn't have any significant incidents during the PQ admission period. So I didn't require, but if I needed additional information, I would have requested for that. At the time, I didn't feel that I needed any additional information in terms of running records since the admission to the PQ.
So just to be clear, was it your understanding that you had the MDT records?
That's correct. That summarizes the week's
Signet MDT
yes.
records. If we look in the running records that have been provided by the Priory to the inquiry, it's Priory document number 4, and it's page 11 of this document. And I'm going towards the end of that entry. Again, we can see, so we see the diagnosis of paranoid schizophrenia. Just above that, we have a reference again to VC completely lacking insight. This was a couple of days before the tribunal hearing. But what is entered by way of a plan of managing VC going forward, so Section 3 should be considered after that, so after the tribunal hearing. depot antipsychotic medication should be considered if detained on Section 3. So we can see, can't we, that the plan of the intensive care unit was, once the tribunal hearing was dealt with, was to convert the detention from Section 2 to Section 3 with a view then of considering depot medication.
Yes.
And the reference to considering depot medication after the conversion to Section 3, did you understand that, or would you understand that as being in the context of if the patient does not consent, then under a Section 3, of course, the patient can be put on a CTO and a depot can be made a condition of that?
Yes.
If we go forward to the note of the tribunal, it's Priory Document 16. And again, the fact that this is it within the Priory documents, that indicates, doesn't it, this was a document that was provided
Yes,
to the Priory.
I had access to that.
If we go to page 3, and on page 3, paragraph 3, and paragraph 3 is summarising the evidence of Dr. Shodakova. So she was the consultant at Signet to the tribunal. And what is said here is that she would be very concerned about VC's own safety and that of others if discharged. You see that in the first line.
Yes.
Now, a few lines down, it states, VC can be safely transferred to less restrictive ward closer to his home, hopefully in a matter of days. Mm-hmm. And of course, he was shortly after this transferred to Priory Arnold, which is in or around Nottingham, isn't it?
That's correct, yes.
But it goes on to say she planned to recommend Section 3 detention on the basis that he's young, early treatment will give him better chances. And in the final sentence of this paragraph, Dr. Shodakova does not think VC has recovered his insight. He has the potential to if he complies with treatment. If his insight does not improve, she would recommend a depot. And so there are a few different aspects to this plan, aren't there?
That's correct, yeah.
So on the one hand, whilst it's being suggested that VC be stepped down, as it were, from intensive care to an acute unit such as Priory Arnold, the basis of the detention is going to be increased from a Section 2 to a Section 3. So this isn't a step down which appears to be put in place as a short stopgap prior to release to the community.
Sorry, you mean the recommendation for Section 3? Is that what you are referring to?
Yes, because there's a few different aspects of this plan. So on the one hand, it's, well, step down from intensive care,
yes,
but put in place a Section 3
that's correct, yeah,
with a view to potentially depot medication.
I mean, she has mentioned here that if he does not gain adequate insight, then she would recommend a depot.
Yes, and so that's part of the Section 3.
Yes.
The implementation of a Section 3 is this is somebody who requires treatment before being released back into the community for the reasons that are given at the start of that paragraph.
Now, what Section 3 means is that at that point, if you consider somebody requires to be detained for a further period, the only option available is Section 3. You can't extend Section 2. You have to put the patient on another section, a different section. That's all that means. What it implies is that patient requires to be detained for a further period.
Yes, he was not ready for release to the
Absolutely,
community.
yes. At that point, sorry.
And you will have seen the entry at paragraph 6 on this page, again from the community care coordinator Claudia Bertels, who referred to before, who is raising concern that VC's engagement was superficial following his previous discharge. He attended appointments and was pleasant, but she wouldn't say we got to the nitty-gritty. And at the end of that, she was not sure that he has ever accepted that he suffers from psychosis. And that's an indication there you had a patient who could be pleasant with those who were treating him, but that didn't necessarily amount to full and proper engagement.
In terms of engagement, I mean, to be fair, I think he has been engaging reasonably well during the follow-up period, meaning meeting with the care coordinator on a regular basis. That's my understanding. In terms of accepting whether he ever accepted that he suffers from a psychosis, my impression was that he was actually struggling to accept a diagnosis of psychosis. I mean, we've seen that with many young patients, especially educated university students or professionals, trying to deal with a serious diagnosis. But it shows that he was lacking insight, that this is a serious illness. It could also be that he was in denial that he was suffering with a severe mental illness.
Can we look, please, at VC's comments? And I want to compare what he said to the Mental Health Tribunal with what was said in the Mental Health Act assessment shortly thereafter. So if we stay in this document but go to page 4 of it, number 8, where it refers to, it starts with a reference to VC. Just over halfway down, it says he felt medication had possibly helped him, but the conversations with staff and his family has certainly helped. Well, the reference to medication possibly helping, is that an indication of limited insight? And it goes on to say, VC said he would continue to take medication in the community. If discharged, he would want to leave hospital straight away, but he might need to wait a day until the accommodation he has arranged is available. And before we move on to the Mental Health Act assessment, just finally in this document, it's page 5, and it's the decision of the tribunal. Roman numeral 5 makes reference to that entry I just read out about the possible improvement. But can you see how this paragraph ends? It is essential that medication is maintained and optimised.
Yes.
And so the view of the tribunal, and one of the reasons for refusing the application made by VC, was with a view to the maintenance and optimisation of VC's medication.
That's correct.
Now, that was a hearing on the 23rd of September. Next day, it's Priory Document 13. We have the Mental Health Act assessment, which took place whilst VC was in Signet. So this is what converted his detention from a Section 2 to a Section 3. And if we go to page 3 of this document, penultimate paragraph, it reads, VC said he has not experienced any psychosis. He said his mental health disorder stopped in early August 2021. and so he stopped taking his medication. Well, the first sentence, that's a complete lack of insight, isn't it?
It appears to be, so I'm not too sure whether so this was in reference to at the point, or whether he was saying that he never suffered. It's not really clear, but it shows that he's not accepting that he was psychotic.
Yes, which shows a complete lack of insight, doesn't it?
Yes. I mean, he has following on, he said that his mental health disorder stopped in early August 2021. So he's acknowledging that he was experiencing symptoms until that point. And the reason he stopped was because he was no longer experiencing symptoms, and he concluded that his psychosis has stopped.
If you look at the final sentence, he does not feel that the beliefs he had could have been due to a paranoid psychotic illness. That indicates, does it not?
Yeah, well, so it clearly indicates that he was not willing to accept that he was suffering from a paranoid psychotic illness or severe enduring illness.
And if we look at the next sentence, which goes into the next page, VC said he does not have any mental health needs, so he does not require treatment. He accepts treatment because he has no choice whilst on section, but doesn't see the need for it and perceives no benefit or side effects. He stated if the section ends, he would leave hospital and resume his university studies and have no contact with mental health services. Now, if the last paragraph did not show a complete lack of insight in your view, this one does, doesn't it?
Yes.
And it's significant, isn't it? Particularly for you as a doctor treating VC within a week of this, in that, firstly, it shows again masking and deception to the Mental Health Tribunal. You see the entry I took you to in the previous document where VC said he would take medication. Well, this is saying something completely different, isn't it?
Yes.
And it is also indicating that he is complying with treatment just because he is on the section or because he feels he has no choice whilst on the section. It is not supportive, is it, of good insight or a commitment, a long-term commitment to taking antipsychotic medication.
Yes, I agree on that, yes.
Were you conscious of that at the time?
I was conscious, yes. I mean, we see, it's a normal pattern with patients who suffer from mental illness during the early part of their illness.
What steps did you take or did you implement to address the concern that whilst at the Priory VC was only taking medication because he was in hospital and he felt he had no choice?
Well, so I made it very clear in my risk assessment documents that he's capable of masking symptoms. So that we need to be really vigilant whether he's suffering with symptoms of his psychotic illness. Well, in terms of supporting him with psychoeducation, so we discussed that we need to engage him as much as we can to engage him in psychological interventions, psychotherapy, psychoeducation, for him to give a better understanding of his mental health condition.
So 1, you say psychoeducation, 2, psychological therapies, and 3, you made reference to masking in his risk assessment.
Yes.
That's what you put in place
Yes.
to manage the risk that he was only taking medication because he was in hospital.
Well, it implies, yes, he was willing to stay in hospital because he was forced to, and he was taking medication because he had to. But if you look at his engagement while he was in the community, that wasn't the case. He was engaging with the care coordinator on a regular basis. He had the option of not engaging, but he did. And there was evidence that he was taking medication and he was reasonably stable for a period of over a year. So what that indicates that he has been taking medications, although he was expressing views against medications or not acknowledging or in denial of his mental health problem. He still continued medication. If not, he would have relapsed quite severely during that period.
You would have, say that again, he would have relapsed quite seriously?
He could have had relapses within that 1 year period or within that 13-month period. So there was no evidence that he was relapsing, but of course he showed signs of some ongoing psychotic features, which he disclosed to the care coordinator.
Did you read the AMP report?
Yes.
Which led to the detention in September, so the detention that you were caring for
yes.
VC during?
Yes.
And did you see in there the reference to a bag of medication dating back to February being found?
Yes, I did.
And that would have concerned you, wouldn't it? Because that would have indicated...
So yes, because it was an indication that he was like... There was plenty of evidence that he was not taking medications as advised. So he may have chosen to take a lower dose of medication or may not have taken medication at times on certain days. So that's what it means.
In light of the CQC's findings as to information sharing and lack of information, what steps were taken with respect to VC to obtain information from other agencies, from the police or from his university?
Prior to admission.
Or during the admission?
No, so there was no need for us to contact police because for any further information at that point, because police did not ask for any information from our service or visited him during his admission to our service, as far as I know. So we normally don't ask for additional information as such. I mean, there's no kind of clear way of receiving information in that manner. I mean, if you are to ask for information, they would say it's an ongoing investigation and would not give. So, so during his admission, we did not ask for any additional information from police.
And is that for the reason that you just gave towards the end of that answer? Because you considered that the police wouldn't give you the information?
Yes, I mean, that's a normal pattern. Like they would not give any information on an ongoing investigation.
And what about in respect of the incidents from May 2020? Would you not want further insight from the police on those matters?
So my understanding, reading through reports, was that there was no prosecution prior to that, incident that led to the admission to our hospital.
In your second statement, it's page 8 of your second statement, paragraph 25, you set out the circumstances in which you would seek further information from the police, and you describe them as where there has been an assessment or admission as a result of or in connection with criminal behaviour, or where the police have been otherwise involved in the circumstances of the patient's admission. And of course that applies, doesn't it, to all of the assessments undertaken on VC up until that point. Apart from the one in Signet, they all had some degree of police involvement.
Yes.
So why did this paragraph of your statement not apply?
So let me read it so I can... Yeah, so what that means is that if the patient was apprehended by police due to an incident in the community and brought to the police, to a hospital, or is being remanded in custody, or if we had a custodial sentence, then I would try to obtain PNC records, Police National Computer Records, for information of his past prosecutions.
But you wouldn't contact the police for further information as to the particular instance of violence or information surrounding it?
You mean to say this particular incident, or you mean previous incidents?
Previous incidents.
No, I mean, so the evidence was that there had not been any previous prosecution for those incidents.
Can we turn, please, to Priory document 165? Sorry, 164, in fact. This is a care plan. It's one of a number of care plans that were carried out on VC during his admission at the Priory. This one is from the 1st of October 2021. So it's at the start of his admission, and it's the Keeping Safe care plan, which has been completed by Amelia Parton. And we can see in the middle of that page a description of the background leading to the admission. About 4 lines down, VC spoke about how he'd got into an altercation with hospital staff at his home. He stated he had thoughts that someone was being raped in his neighbour's home. Now, that isn't a correct description, is it, of the circumstances leading to his third admission?
Yeah, I agree, yes.
And describing what had happened as an altercation, it was in fact with police, not hospital staff. That is a significant understatement, isn't it?
That's correct, yes.
And if we go down in this page, please, we have a reference there in the middle of the page. What do the MDT want me to achieve? Well, there wouldn't have been an MDT meeting at this point, would there? Is what's in that box?
Yeah, so what that means is that the expectation from the treating team, from him.
And then towards the bottom, what the nursing team will do, I want to look at the very first entry there, provide one-to-one nursing session every week. Now, that was not implemented, was it?
I have seen one-to-one sessions, but I don't think they were every week.
No, so that was not implemented, was it?
Yes, I agree, yes.
We can look at the records. It's Priory document 25. And if we go to page 5 of this document, it's the entry at the top of the page, 13th October 2021, 1657. You can see there's a reference to a nursing one-to-one, a key worker session. Now that comes almost 2 weeks into VC's stay, doesn't it?
Correct, yes.
Why was that, if this was supposed to be weekly?
I cannot really comment why. I mean, it's noted as a one-to-one session, so some nurses do make it a point to highlight that it was a one-to-one session because that's part of their role, or the job role or the expectation. If you're a named nurse key worker, then you must provide a one-to-one session.
Yes, but this is the first, in terms of the chronology, this is the first one-to-one session that's in the notes, isn't it, for something that's supposed to occur weekly?
Yes.
And the only other one-to-one session that we see is page 3 of this document. And it's the penultimate entry. title one-to-one session. But if you read through that it appears to be a pretty brief interaction, doesn't it?
That's correct. Yes.
VC does not engage, does he, with that one-to-one session?
Yes.
And so rather than there being a one-to-one session every week, as was envisaged at the start, there's only 2 offered, and one of them VC doesn't engage with. Is that a fair summary of the one-to-one sessions? If we go now to Priory Document 171, please. We're now looking at another care plan. This is care plan keeping connected. So previously we looked at a care plan for keeping safe, but that care plan didn't change, did it, over the course of VC's stay?
Sorry, I didn't follow that question. Sorry, say that again, if you could.
Yeah, so I've moved on to another care plan. This is the keeping connected care plan.
Yes.
Previously, we were looking at the keeping safe care plan.
That's correct.
But in substance, the keeping safe care plan didn't change from the 1st of October, did it?
So are you referring to whether the keeping safe care plan changed from since 1st of October? Is that what you're referring to?
Yes.
Until when, sorry?
At any point in the rest of the admission?
No, it's regularly reviewed at each ward round, so you would see updates. If you scroll down, you would see updates to each of those care plans.
There are updates, but there's no changes. There's no
yes, if there's no change,
changes.
then there's no change, yes.
And so now we're looking at the keeping connected care plan. And we have, again, towards the middle of the page, what do the MDT want me to achieve? And the first entry ends working towards a discharge plan into the community. But was there ever a discharge plan created for VC?
So what that means is that progressing with Section 17 leave, getting in touch with the university, so basically returning back. So basically plan to discharge him eventually.
So it's not referring to a document?
No, I don't think so, no.
The next entry is VC attending his weekly ward round and engaging with all members of the MDT, and we'll come to the MDT entries in a moment. The one after that, the MDT would like VC to engage with the therapist team so he can attend activities and groups which are of interest to him. And again, that did not happen, did it?
Yes, so they tried to engage him in activities, but he wasn't interested because I think he was quite preoccupied resolving his own issues, which is of interest to him, which was actually returning back to studies at the earliest, resolving his housing issue, and he was focusing on his studies. I mean, he was reading, he was going on his laptop quite a lot. So he was quite a busy person in terms of his own interests. That's what it means.
He was in the hospital because he needed treatment.
That's correct, yes.
And part of the treatment plan was for him to engage in therapies.
That's correct.
There were benefits to that, aren't
yes, of
therapeutic
course, yes,
benefits. Yes. And that part of the treatment plan was not implemented, was it?
No, I think they did try to, implement that by offering sessions. But
VC declined.
Yeah, he did decline. And I think he politely declined, saying that he was busy with some other things. And some of the activities offered to him may not have been of any interest to him, because we do offer it to all patients, and we try to kind of capture their interests as well, such as like, going to the gym, which would have been an activity of interest to him.
The
but
running
on this
records
occasion,
show, the running records show that in his admission, there were 3 activities that were offered to him. So table tennis on the 5th of October, a cricket match on the 15th, and a walking group on the 22nd. On each occasion, he declined. So he wasn't engaged, and there was nothing else offered. He wasn't engaged in any...
So he didn't engage in those, yes.
And there was no other therapy offered to him, was there?
Not that I know of in terms of any other different types of therapies.
Next entry, the MDT would like VC to engage with any external support network during his admission. That did not happen, did it?
As far as I know, no, that didn't happen, no.
Next one, MDT would like VC to engage with the psychology team to support a safe discharge plan. That did not happen, did it?
That didn't happen either.
So in respect of the aims of the MTT as set out in this box, which doesn't include the one-to-one nursing plan, which we've already established, was not implemented according to plan. The only one VC did comply with was turning up at the MDT.
And attending to his medication times. He was complying with medications.
Well, we can go through the records, but in fact he doesn't always turn up to medication, does he? Sometimes he needs prompting, he doesn't go to medication for medication.
As with most patients, sometimes they do not turn up. Staff have to go and remind them.
So he wasn't fully compliant with that either, was he?
No, I would say he was compliant with medication. Otherwise, he would have resisted, he would have refused. But on each occasion, as far as I know, when offered, he did take his medication. And there were occasions that he voluntarily attended the clinic and had his medications.
Mr. Carr, is this time for a break, do you think?
Yes, that would be an appropriate time.
All right, we'll take a break until 1:45, please. Thank you. Please stand.
Dr. Gosling, before the break, we identified a number of failures to comply with the plan that had been put in place so far as one-to-one time with the nurse, engaging with therapies, offers of therapies. Those were failures of yours, weren't they? You are the responsible consultant, and it was your job to make sure that the plan was implemented.
I mean, I have the overall responsibility as part of his detention, but the responsibility is shared among all the different specialties. So it's a shared responsibility.
We spent some time looking at the care plans. Can we look, please, at Priory Document 9? This is a risk assessment, the first risk assessment that you carried out on VC. Do you see that? The risk of violence and aggressive, intimidating behaviour is reduced from high historical to medium current, and is kept at medium for non-adherence with treatment, both current and historical. What was the basis for reducing from high to medium so far as violence was concerned? Is it because he was currently an inpatient?
Yeah, so it's current risk, so it relates to the risk at the time. So there was no incident to indicate that he was violent or aggressive or intimidating.
And at the bottom of the page under other risk factors, you identify, don't you, may be able to mask symptoms to get discharged?
That's correct, yes.
Page 2 of this document sets out information at the top. This is information which predates, doesn't it? There's an update there for August, but the first two paragraphs predate his time at the Priory.
Yes.
What this document doesn't do, and what none of your subsequent risk assessments do, is consider the risk in the future.
I mean, the past risk patterns gives an indication of potential risk in the future. That's the understanding in any risk assessments. I agree that it doesn't specifically say that in future this might happen, but it's giving a pattern of risk incidents that would give a reasonable understanding of potential risk in the future.
It does not identify the risks of VC becoming non-compliant when he is in the community. We spent some time before the break going through the history and the records, and following the previous admissions, VC had become non-concordant. Your risk assessments do not address that risk factor, do they?
In terms of non-concordance, we have...
In the community?
Well, it hasn't, this risk assessment has not predicted what might happen in the community at this moment.
And this risk assessment was completed at the same time as your first MDT. That was on the 7th of October. It's Priory document 159.
No, so this was done on the 4th. The first MDT review took place on the 7th, so there was another risk assessment.
Yes, if we get that first MDT document up, it's Priory document 159. Oh, yes, this is a few days on. This is the 7th of October. Now, at page 3 of this document, there are the patient's views and feedback section. In the middle of the page, he did not agree he had a relapse on this occasion, said he was too stressed and he overreacted when police got involved. That is a significant underplaying, isn't it, of the circumstances leading to his admission?
I would agree to a certain degree. In his mind, he acknowledged that he shouldn't have reacted in that manner. But yes, I would agree that he has undermined the seriousness of the incident.
Did you not challenge him on that?
No, I believe not on that occasion. I can't say I have. I have no recollection whether I have.
In the next paragraph, it refers to him preferring to be back on aripiprazole and to come off haloperidol because of a side effect. He said it was making him salivate a lot. Aripiprazole is the medication that he had previously been prescribed and discontinued, become non-concordant on, isn't it?
At certain points, yes.
And you agreed to that request, didn't you?
I did, yes.
Now, why didn't you take steps during this MDT, or did you take steps during this MDT to ensure that VC did engage with therapy, did engage with nursing, and wasn't permitted simply to isolate in his room during his stay at the Priory?
Are you asking me why sorry, I didn't really understand the question.
Well, this is a MDT on the 7th of October.
Yes.
And the notes up until that point indicate that VC was basically spending his time in his room, not engaging.
Yes.
And that is a theme which continues throughout his stay in the Priory, isn't it?
Mm-hmm.
And I'm saying, why didn't you take steps at this MDT, or indeed any MDT, to ensure that he was engaging and he was seeking therapy and he was having one-to-one nursing sessions?
Right. Well, I mean, in terms of engagement, it is it's quite common for patients, especially young patients, university students, professionals, they tend to, when they are improving or when they are improving in their mental health, they tend to kind of alienate from the other patients and then tend to kind of remain in their own rooms and focus on their interests. So it is not unusual for patients to isolate themselves because for me, for various reasons, like they do not want to align with the other patients, feeling that they are too unwell, I need to focus on other things. That's one of the reasons. But in terms of engaging with staff and therapy and activities, yeah, we should have been more proactive. I would agree that we should have been more proactive.
You carried out a risk assessment on the same date as this MDT. It's Priory Document 10, and we can see that the risks of non-adherence for treatment and violent, aggressive, intimidating behaviour has reduced from what you previously ranked it as medium to low.
Yes.
What was the basis for you reducing it, given that there had been no engagement, or very limited engagement, by VC on the ward?
So this is referring to violence, aggression, intimidating behaviour. There was no such, there was no evidence to suggest that it was still present.
It was simply the absence of incidents
That's correct,
in the
yes.
last few days. And again, no other material looked at. No other material looked at for the purposes of the risk assessment. What were you taking into account?
So it's, yeah, well, simply the feedback we discussed during morning meetings. So I get a good understanding of, the whole team gets a good understanding of what's going on with each patient. You know, no significant incidents were highlighted at that point.
You have another MDT on the 14th of October. We see that at Priory Document 160. And at this stage, he's been allowed, you've implemented his wish, haven't you? You've allowed him to transition to aripiprazole.
I think that transition commenced from the 7th MDT ward round. So by the 14th, what we call swapping of medications had taken place and gone further forwards. So we were in the process of reducing haloperidol dose and increasing the aripiprazole dose.
Now, at this MDT, you were considering, weren't you, rescinding the Section 3?
That's correct.
And that's despite, if we look at page 3, in the current mental state, sorry, page 4, and just towards the middle of the page, Section 3 discussed. He said, you suggested the section be rescinded if VC agreed to remain informally for a few more weeks. At this stage, VC was still, for the most part, isolated on the ward, wasn't he? He wasn't engaging.
He was isolating, yes. He wasn't engaging in the some of the recommended therapy activities such as OT and psychology.
Yeah, so isolating, no therapies, and unclear, as you say, whether he had insight.
He was fully compliant, and I think he did demonstrate a degree of insight by requesting to trial him back on his previous medications, which was helpful, which attributed to his improvement of symptoms. So that demonstrated adequate insight to me.
Why does requesting a change of medication in circumstances where you have seen in the Mental Health Act assessment, VC said that he was only taking medication because he was under section, why does changing the medication demonstrate insight?
But we know that although he said that he was taking medication while he was in the community, there was evidence that he was taking medication. If you look at care coordinator's notes, she indicated she wasn't convinced that he was taking regularly, but her records imply that there was a good degree of engagement and concordance.
This was the third time that VC had been detained in a relatively short period.
That's correct.
Each time unmedicated and each time leading to violence.
That's correct.
And so it was important, and it was key really to the period of treatment that you had him for, to ensure that the same thing didn't happen again, because a pattern had emerged, hadn't it?
That's correct, yes.
And in none of your risk assessments do you identify that pattern?
In terms of medication compliance.
In the community?
Well, I mean, we have identified, I'm not too sure whether I have kind of specified, but we've identified there is a potential that eventually or later on he may not be fully concordant. That's what it means.
The MDT of 14th of October, Priory Document 160, that's the MDT that VC's care coordinator attended, wasn't it?
That's correct, yes.
And it also came 4 days after it being noted in the records that VC had brought a hammer in a rucksack onto the ward. Yes?
Yes.
And you deal with this in your witness statement. It's your second witness statement at page 55, paragraph 206. And you say, my recollection of his explanation is that he picked this up as he was moving to a new property and needed a hammer to hang items. It was detected during a search upon returning from community leave. What's clear is that he did not have that hammer, did he, when he was first admitted?
That's correct, yeah. And this incident took place on the 10th, not after, on the 10th or that weekend.
Yes, I said it's noted in the records on the 10th.
Yeah, okay.
Now, your discussion with VC, it is not noted in the records, is it? This explanation of wanting to hang items up?
No,
It should have been, shouldn't it?
It should have been, yes.
And it's not mentioned in this MDT discussion, is it?
I agree, yes.
And it should have been?
It should have been, yes.
Did you communicate it to Miss Birtles? The fact that
no, I cannot remember.
With,
if I had communicated, it would have been recorded.
And the account of having a hammer to hang up items, it was completely implausible, wasn't it?
Well, I mean, it was plausible in his mind, but we were skeptical. So I remember having a discussion with a nurse or somebody that we should keep an eye. He could still be paranoid.
Well, at that stage, he's still detained, isn't he? He's still detained subject
he was still detained. That was early part of his admission when he was supported to go out to the community in order to bring items that he wanted to get on with his studies, which included some books and laptop and his charging cables and so on.
Yes, he didn't need a hammer for that.
No, he didn't.
And the suggestion that he needs it to hang items in a new property, well, he hadn't secured a new or alternative
That's
accommodation.
correct, yes. I mean, this was his explanation. So all
his explanation was implausible, wasn't it? Because he didn't have a new property. He was on section...
No, at the time, yes. At the time, it wasn't valid. But we didn't go to challenge him on that.
Why didn't you go to challenge him on it?
Because, I mean, if somebody's insisting that, that's their version of, thoughts or plans, then there's no point challenging him at that point. That's not the right point to challenge that. That's my
And if it didn't need challenging, what it certainly needed was, A, it needs to be reported as an incident, and it should have been investigated.
It should have been reported as an incident, yes.
And that was a failure, wasn't it?
That I agree, yes.
Failure on your part?
Failure on the part of, the MDT or the staff member who was responsible for that event.
And it required a risk assessment, didn't it?
Well, it would have required, every incident, requires a risk assessment.
The incident with the hammer is not reflected in your risk assessments, is it?
No.
And this is somebody who's come back with something that can be used as a hammer, used as a weapon.
Yes.
And has given an explanation which, Dr. Guru Singh, it sounds like you thought was nonsense.
Yes.
And so that should have led to a change in the risk assessment. It should have led to a new risk assessment.
In terms of when I knew about it,
Yes, from the point you knew about it, at any point up to discharging him, when you are risking violent, aggressive, intimidating behaviour...
That should have been, included in the risk assessment
And it's not included in any of them, is it?
Sorry?
It's not included in any of them?
No, it's not. It's been missed. I mean, I admit that it's been missed to be included as an incident, but in terms of any harm occurred or to anyone, there was no harm. That's why it may not have been highlighted enough.
Now, you decide to rescind VC's Section 3 detention with effect from 18th of October.
That's correct.
And he's not actually discharged until the 22nd.
That's correct.
But as at the 18th of October, what has changed from the point of VC's admission to the point of discharge? In light of what we've seen written in the Mental Health Tribunal documents, Dr. Shoylukova's view, Dr. Shoylukova's evidence to this inquiry is that she expected VC to be detained for a period of months.
Yeah, I mean, that's not my view. I mean, that's, that consultant's view, and which I don't agree at all.
What had changed in VC's presentation, given he didn't engage, he was isolated, he didn't have any of the therapies that the MDT thought he should have, he didn't undertake any activities, and he had turned up at the ward with a hammer?
Well, I mean, I didn't want to kind of link the hammer incident to his general presentation. In my mind, he was detained for a period of nearly 8 weeks or so, and at least for the last 6 weeks, there were no incidents of any significance in terms of violence, intimidation, aggression towards staff or any other patients. So he has managed his risk really well. In terms of his medication compliance, he has complied really well throughout the admission period. In case of his engagement, he has engaged reasonably at times, at times when he was on the PQ, in some of the psychology therapies initially. So there was no reason for me to justify detaining him any longer based on, that presentation being stable relatively, as far as we can observe, for a period of 6 weeks.
So, Dr. Gerasing, we've been through the records. We've seen what the risks are in respect to VC. In particular, it's becoming non-concordant in the community. What steps did you take and what plan did you put in place to protect the public following VC's discharge from the Priory, given that known risk of him becoming non-concordant in the community?
Well, so in terms of risk to public, I mean, we did assess that throughout our admission period.
My question was about assessments. What steps did you put in place?
In terms of
protecting the public?
Well, the patient was, so the expectation was the early intervention team to have been involved as they have been in the past. So to carry out regular assessments of his mental state to ensure that he's not relapsing and to ensure his medication concordance as well.
We went through some early documents and you said that you were aware that the early intervention team had been considering depot. We went through the documents from Signet, Dr. Shoylukova, and you've seen the recommendation that she was making for depot. Despite that, your witness statement and your evidence is that you do not recall having any discussion with VC about depot.
That's correct.
There's nothing in the notes to suggest you had a discussion
no.
with VC.
Yeah, but my understanding at the point was that he was quite resistive of the depot plan.
Something that you should have discussed with him as his consultant and responsible clinician. It's something that you ought to have
on reflecting, I should have, discussed further. But my view was that, we see this all the time, especially with younger people, that they are quite reluctant to be on a depot. They would rather have the tablet form. So it's quite tricky. It takes a while to build that therapeutic relationship in order to convince the patient the benefits of being on a depot. And I was expecting the community team, the early intervention team, and the care coordinator who build a good therapeutic relationship with him to persuade him to agree to have the medication as a depot.
But the point of there being a Section 3 detention, or one of the benefits of there being a Section 3 detention is, one, you could have started depot during that detention, couldn't you?
Mm-hmm.
And two, you could have ensured that VC's release to the community was subject to a CTA where taking depot was one of the conditions. Those were two options that were available to the section.
I'm fully aware of
those. They were
those.
not available, were they, to the community team?
I'm fully aware of those two options, but in terms of feasibility of those two options, if you look at the powers of community treatment order, it's not a mandatory condition, so you can't really force somebody to go on a depot, and especially in the community, if somebody is resistive, there's no way of administering a depot medication against a patient's wish.
Chair, those are my questions. Thank you.
Yes, thank you. Mr. Maloney.
Dr. Gurusingh, I'd just like to ask you, if I could please, about the MDT of the 7th of October 2021, which is PAJR 40159, please. And if I could take you to page 3 of that. Mr. Carr has already been through with you a lot of the detail in relation to this, but if I could take you down to the middle of this paragraph, where he says that he did admit to third-person auditory hallucinations, thought intrusion, and abnormal beliefs in the past. He stated that they went away when he was on aripiprazole. He preferred to be back on aripiprazole and come off haloperidol. He said it was making him salivate a lot. And that was the, as it were, a summary of the exchange between you and VC in relation to his preferred medication on the 7th of October of 2021. Now, of course, he's displaying a certain lack of insight in the sentence before the first one I took to you, where he said he did not agree he had a relapse on this occasion, said he was too stressed and he overreacted when police got involved. So perhaps not being entirely open with you at that stage, given what you must have known about the circumstances of that incident with PC Pritchard, and I won't repeat all the details, but there he is talking to you about medication. And may I just ask you this? Him having said that the hallucinations went away when he was on aripiprazole and that he'd been having side effects with haloperidol of salivating. Was at that MDT, was that the first you had heard of any of VC complaining of salivation, or was there something in the notes that the nurses had found that this essentially corroborated?
No, I cannot really recall whether there was any conversation. I might have been. I can't really comment for sure. But I know for a fact that there's a difference between haloperidol and aripiprazole in terms of side effect profile. So
so of course,
yes,
different drugs have different side effects. That is a matter of fact, which you know for a fact, as any responsible clinician would know for a fact. The question is whether or not there was anything in VC's notes whilst he was at the Priory to suggest that he was complaining of salivation that you saw before you did this MDT on the 7th of October of 2021.
I believe there was some notes. I believe there were, but I can't really confirm whether I've actually seen, or my decision was based on, if you're asking whether my decision was based on corroborative information from other members of staff. No, it was during this discussion when he reported that he is struggling to use haloperidol because of the side effects. Of course, I did listen to him.
Yeah, of course. Because, of course, and it's very straightforward, that if one simply uses a search engine and looks at side effects of haloperidol, then salivation will be referred to, won't it?
Not necessarily. I mean, you can't, make such, inferences from that because...
No, that's not what I asked you, Dr. Gurusingh, and please forgive me for talking over you. I don't want to be rude, but there's limited time. If one uses a search engine to look for side effects of haloperidol, then it will say salivation, won't it?
I would agree, yes.
Absolutely. And that's why people can know that as a fact, even if they just by looking at a search engine. Now, you saw his request as a significant turning point in his recovery, didn't you?
I did, yes.
And just to get the full extent of your confidence in that as a significant turning point in VC's recovery, can I take you to paragraph 145 of your statement, please? And that's at page 39 of WITN 010202. Just the context to this, please. Page 39, paragraph 145, and this is how you sum up that interaction with VC on the 7th of October. I consider acknowledging abnormal experience such as hearing multiple voices, being able to express his concerns about some of the medication's side effects and suggesting alternative but effective medications as significant turning points of VC's recovery. And then if we could just go to paragraph 151 just to reinforce that. That is over the page, essentially. I believe VC understood the importance of medication, as he himself suggested change of medication to aripiprazole, stating it is more effective and tolerant in the past in terms of relieving his symptoms, and that you were reliant on his EIP to continue to build therapeutic relations to ensure his medication concordance. Now, in order to feel that this was a significant turning point in VC's recovery, you would have to have a full appreciation of VC's history in relation to medication, wouldn't you?
Yes.
And are you aware that VC told the community team in November 2020 that during his second admission, he'd lied about the effects of aripiprazole? You aware of that?
Yes.
Yeah, and then were you also aware that during a recent mental health act assessment, he'd said he'd only accepted treatment whilst on section to get discharged?
I'm not aware of a recent one, but back then, yes.
Not long before you saw him, in a recent one that was recent before you seeing him, that he'd said he'd only accepted treatment whilst on section to get discharged.
Yes, I agree, yes.
And then in the tribunal decision, which presumably you saw, Dr. Gurusingh, that essentially at paragraph 8, and I'll save time, won't bring this up, he said that the voices had not stopped when he was previously discharged and living in the community until August 2021, when they'd stopped with no particular prompt. And that was only just a few weeks before you were seeing him here on the ward on the 7th of October. He was telling you something that he'd not told others. Did you bother to check back and see whether or not what he was saying to you about about essentially his positive experiences with aripiprazole, his willingness to be concordant with aripiprazole, whether or not that might be just in some sort of variance with what he'd said to other practitioners before, and whether or not you ought to be sceptical about whether or not this was a significant turning point in VC's recovery?
We were always sceptical about medication compliance. There's no doubt about it.
Thank you very much, Dr. Gurusingh.
Yes, Ms. Cartwright.
Good afternoon, Doctor.
Good
I ask questions on behalf of the survivors. Can we please display PAGR 00014? There may not be enough zeros. Because you've essentially said it was the decision of the MDT, but it's right, isn't it? You, as the responsible clinician, are the relevant individual who has made the decision and discharged VC from his section 3. And we see there confirmation of that as the responsible clinician, that it's you on the 18th of October that makes that decision significantly to change VC from a patient detained for treatment to become an informal patient on the 18th of October. And so whilst you sought to say, well, you're just part of a multidisciplinary team, when you're making a decision pursuant to Section 172 of the Mental Health Act, you have to satisfy yourself in respect of those statutory criteria. Would you agree?
Yes.
And so you do have a significant responsibility for that decision. Would you agree?
I agree, yes.
And would you agree also that you had provided to you the last Section 3 consideration from the 24th of September that had made absolutely clear from the assessment that took place at Signet that VC had told the treating team he would not comply with his medication in the community when discharged?
My understanding is that his views change and his views are likely to change.
Well, you say that, but that's not documented anywhere.
Sorry, in terms of...
You say that, but bearing in mind this was the opportunity, VC's on a Section 3, where he can be discharged on a community treatment order with a power of recall while subject to a Section 3. And there's significant information in the Mental Health Act assessment that took place at Signet that placed him on the Section 3, that from VC saying, I take medication when I'm in hospital, but I won't take it when I'm in the community.
Yes.
And so let's just look at your entry, please, in the records that you did make when you reduced VC to an informal patient. It's PAGR, however many zeros, 25, at page 3. So PAGR, thank you. So we can see the entry there, for your entry. So 18th of October, revocation of Section 3. Thank you, just a little higher. VC was reviewed in his room this afternoon. He was working on his computer. He reported he's found a private accommodation close to his university and that it's available to move in. Advised that his Section 3 will be rescinded from today at 4 o'clock. Paperwork completed. He was advised to secure the property and discuss possible discharge plans on Thursday. Where is your recording about the statutory criteria? Where do you address mental disorder? Where do you address the nature and degree of that mental disorder? Where do you address the issue of appropriate medical treatment? Where do you address risk to members of the public or risk to VC to justify your decision to discharge VC from the Section 3?
Yes, I agree. I should have explained my assessment there. This section rescinding decision was based on my MDT review on the 14th. I was prepared to rescind this section on that date, and I carried out the assessment. And then I thought, okay, let's trial the weekend as well. Let's see how he does with leave and medication compliance, and then I'll review him back on Monday. And that's when I decided, well, things have gone well as expected, as per plan, and there was no reason for me to justify continuing the detention any longer.
But let's then look at the last risk assessment, because you didn't complete a risk assessment on discharge, and we'll look at a document in the...
Sorry, what does that mean? That's wrong.
Pardon?
I have completed a risk assessment on the last MDT.
So I'm going to take you to the last,
yes,
the 21st, the one that we do have for the 21st of October,
yes,
before VC actually left, please. If we could go back to that. PAGR 12. And you've already been taken to this document, so I just want to focus on the significant aspect, please. On page 2, we've still got recorded on this document, doesn't agree with his diagnosis. He has no support network in Nottingham, unclear whether there's another resident in the flat. VC has been reluctant to discuss anything in detail.
Sorry, which part are you referring to? Sorry.
I'm on page 2.
Yeah.
Where the
well, that's historical, risk evidence that's there.
But again, this is saying he's been reluctant to discuss anything in detail, and certainly you've not documented in any of the entries that VC is now has insight, that he's addressed the issues of risk factor that led to his detention.
So that's actually covered in that ward round, so that's what I'm saying. So,
well,
so you're referring to the 21st, which is the discharge date.
So this is the last risk assessment document
yes,
that we have.
so there was an
21st
MDT
of October.
review on that date. So that's when we discuss his presentation.
Well, let's then, so you're saying we need to go to the clinical entries to look for the justification?
In terms of discharge on that
Yes.
date? Yes, so that's captured in the MDT review.
Well, I'm going to suggest to you that your risk assessment was woefully inadequate in the circumstances of the consistent risk information that was available. And so then can we look at the discharge? Because where in fact was VC discharged to? Because the Priory provided two different addresses. So let's just look first of all at NHFT 66. So this is the patient transfer and discharge checklist that was completed on the 27th of October. Patient address 278 Queen's Road, Beeston. This document then suggests that should be a current risk assessment updated at discharge. And the person completing this was not able to say yes, no, or not applicable. And if we move down, please. Just show the page. Thank you again. So that was the notification that went that has an address for VC, which is consistent. If we just then look, please, and let's perhaps just look there before we fall off here. Follow-up arrangements, data planned NHS team contact, and or prior outpatient and or prior daycare appointment. Absolutely nothing by way of the follow-up arrangements following discharge. Would you agree?
Sorry, if you could repeat that.
So this is the transfer that gives his address, and we see at the top a different address to that we'll look at in your entries of 278 Queen's Road, Beeston. This patient transfer and discharge checklist is also supposed to include the relevant information as to follow-up. We could just go back down, please, the page. And again, absolutely absent on follow-up arrangements, which is what's required for a safe discharge of a patient back into the community.
Yes, so this is an audit carried out by...
That isn't the audit document. I'm going to take you to the audit document. This is the patient transfer.
No, so this is an audit document carried out by an admin staff member to confirm what they have done and what they have not done.
Well, let's look at the audit document then before I take you to the medical records. PAGR 163. So this is the audit discharge tool, and we can see from this the auditor now, so this is the person that's supposed to check that Priory have done everything that they should have done. Phone call was made prior to discharge to crisis team, sorry, on page 1. Thank you. Yes. We'll come on to show that that didn't take place. Would you agree?
Sorry?
A phone call was not made to the crisis team prior to discharge, and we'll look at that in a moment in the medical records. Would you agree? But notwithstanding that, this audit tool said yes, it had.
My understanding was that a call was made, but I can't confirm because I didn't do that.
And then again, if we look further down on this audit document, patient was discharged to home address. Crisis team 72-hour follow-up arranged. And again, we'll look together that in fact that's not correct either. Would you agree?
I wouldn't agree because my understanding was that crisis team was involved. Crisis team was informed.
Well, that's why I'm going to suggest again that this was not a safe and appropriate discharge. And would you agree that this audit hasn't picked up that there are two discharge addresses that appear in the notes, the Beeston address, but also the address that you'd put in the note, which is the address where VC went on to carry out the fourth incident, which was the property, which we'll come on to look at in your notes in a moment. Did you pick up on the fact that there are two different addresses for discharge for VC?
I have picked on, while scrutinizing these documents, I have.
You have. So
Yes.
you can see that the Priories have your address that you've recorded in the notes, but also the different address that's given that was fed to the community team.
What was fed to the community team
Well, let's look at
had
that
the
then.
correct address on it.
Well, who knows, because nobody ever went to
Nobody
that
knows.
address.
So, I mean, that's the address that he gives us. So we mentioned that address.
It is, but who knows, because actually a safe discharge requires, what should have happened was Section 17 leave whilst he was on detention overnight, so it could properly assess he was ready to be discharged back to the community.
Not necessarily. I mean, he had the option of going on overnight leave, but we wouldn't have necessarily gone and checked where he was going on, where he was staying.
So let's then look, please, at NHFT 168, the Rios, please, at page 193.
Ms Cartwright, you're already over time.
I'll just do this and then the other address, just to support the two.
How long is that going to take?
Probably 2 minutes, please.
Right.
Thank you. Thank you. So this is bottom of the page, 22nd of October. This is the community team over the page. Thank you. Rang prior to ascertain what happened at VC's ward round. He was discharged this morning, and we see there the new address that had been given, 278 Queen's Road, Beeston. And then this note continues to show that the crisis team had not been contacted. They were not able to essentially take on VC. And so I'm going to suggest that shows there had not been a safe discharge for VC, because the things that the Priory should have done hadn't taken place. And just to pick up then...
No, it doesn't give that inference, because the care coordinator was duly informed. She was well aware. She basically contacted the ward, and she was made aware that the patient was going to be discharged the next day. So there was a follow-up plan.
To 278 Queen's Road, but then...
So that's the address that he's given when he was contacted by the colleague of the care coordinator.
Well, let's then go to your PAGR 25, please, at page 2. And it's also the address that's in the further discharge note that the doctor completed. PAGR 25. Thank you. And it's... If you just go, I think, sorry, it's one more page. Sorry, to page 1 maybe then, please. It's the entry, please, with it. Thank you. And if we just go down a little. 20... Thank you. We see, could it just be expanded? So you've recorded 22nd of October, VC was discharged to his new flat. We've got the flat 15 Madison Court, Derwent Way, which was also the address that was in the broader discharge note.
Mm-hmm. That's the address that he gave us.
But it's not the address that was placed on the transfer for discharge. So there's two different addresses.
In the discharge summary, in the discharge letter, this address was mentioned. That's my understanding.
It was, but also there's a different address which has been given on the transfer, which is the address that the treating team had, the community team. They don't get that other note till much later. So essentially, where did VC go? Did he go to flat 15 Madison Court, or did he go to Beeston Road? We
wouldn't know. I mean, he had the option of going anywhere he wants when he's discharged, right? But he had a contactable telephone number, and he did respond when I contacted him. So he was contactable, and he was willing to engage. And my assessment was that he was engaging.
Thank you. Thank you for allowing me the extra time.
Mr. Straw.
Dr. Grising, I represent VC's family. I'd like to ask first about VC's mother, Celeste Callicane. Did VC decline consent to invite Celeste to attend MDT ward rounds?
That's correct, yes.
And so presumably, because of that, you didn't invite her?
We couldn't invite her.
And did VC also ask you or someone else in the team that you, the responsible clinician, don't contact his mother?
That's correct.
And so again, presumably you didn't contact his mother because of that?
No, I did contact the mother.
You did?
Yes.
When did you do that?
I can't recollect exactly. That I, accept that it was an omission. But if you can corroborate that with his mother, whether I have contacted her or not, because I did phone her. I tried twice or thrice. It was difficult, but I managed to speak to her, and I had a conversation with her and obtained background information.
But if he'd said he didn't want you to contact his mother,
yes,
why then did you contact her?
Yes, so patients can decline consent to share information. It doesn't prevent us contacting and obtaining information.
But you'd agreed me. Well, you'd said earlier that VC had declined consent for you to contact his mother.
What I implied that was sharing information rather than contacting. But it's still. Even if he declines consent to contact, I can still contact and obtain information.
And you've accepted just now there's no note of you doing that?
Yes.
You would have made a note, wouldn't you, if you had contacted her?
I would have, because I think it was out of hours, possibly from home I may have. But as I said, you can always corroborate that with his mom, whether I have contacted her or not.
She doesn't remember you doing that. Do you think you might be mistaken?
Well, there's nothing for me to prove, but this is I have sworn under oath that I have, it's accurate, so that's all I can say. If she can't remember, or if she's denying that. Because it was following a request from her to speak to me, so I made it a point to contact her.
She wasn't consulted prior to discharge, was she?
That is correct, because he didn't want to share, plans. But during that conversation, now you're saying that, she has no recollection, or she's, denying that she was contacted. I think during that conversation, I remember discussing about him not having a place to go to, and Beacon Lodge, and imminent discharge plans is progressing well and all that. So I'm surprised why she didn't, or she cannot remember. Probably, lots happened after that. So that may be the reason, but I can only swear on oath that I have done that, so that's all I can say.
So she wasn't consulted prior to the discharge, and you said just now that the reason she wasn't consulted was because VC declined consent for you to contact her.
No,
VC
right? Declined consent to share his management, his care during that admission period.
But if you're claiming now that you could contact Celeste...
I could have said, I could have contacted her and said, well, he's discharged now. I could have.
Well, why didn't you?
Well, I don't have, I don't have a reason as to why. Things happened quite quickly, and I can't really say why I didn't or did.
But this is a really important stage, isn't it? She has a right as the nearest relative to be consulted prior to discharge.
She has the right, but if a patient is adamant that not to share any plans in terms of care or plans with somebody else, then we have to respect that request. Now, in terms of her knowledge about discharge, I was under the impression, and I think that was pretty accurate as well, that she was in contact with VC on a regular basis, and VC probably would have disclosed to her that he's going to be discharged sooner, would have, but I can't confirm that, because they were in communication on a regular basis, and she did phone the ward as well. So she was talking to staff were assuring that he's doing well and is going on leave, found a place, and so on.
But it was important, wasn't it, for you to consult her for two reasons. Firstly, she could have given you important information about his circumstances on discharge. Accept that?
Circumstances as in?
Whether he had a safe place to go, whether he would have support on discharge.
No, I knew, so in terms of support, I knew that mother was quite caring, and she was in regular contact with VC on the phone, looking after him, his interests. But in terms of other support, I knew that he didn't have much support, and that was one of the reasons that I kind of decided I'm going to check on him, see whether he needs any additional support, how he's coping. Because if you note my records, you would realize that after discharging him from my care, I did pick up the phone and contacted him and find out how he was doing at that point.
And a second reason why it was important to consult her was to make her aware and ready that he was being discharged. You'd accept that, wouldn't you?
Sorry, say that again, please.
So my last two questions have been, there were two reasons why it was important for you to contact her. The first was so that she could give you information, and the second was that so you could make her aware and ready for him to be discharged.
Yeah, well, one of the reasons I contact family members, even if the patients don't consent, is to reassure them, they are how they are. I mean, in terms of to reassure that they are being cared for.
And sorry, I still don't understand your evidence here. So you say that you accept, you do contact patients, family members, even when the patient doesn't consent, and you claim to have done so earlier in the admission. Why didn't you at the point of discharge? I can't really give a reason as to why. So the MDTs happen in such a way, I wouldn't be able to, pick up the phone and contact her, and she was not easily contactable. Anyway, I didn't make an effort, so I'm not kind of trying to find excuses. For some reason, it didn't happen that way. Are you sure you're not trying to find excuses? She was, you say she wasn't easily contactable. In fact, she regularly spoke to the medical team.
That was at night, late night-ish, like on a regular basis at night.
Okay, thank you very much.
Yes, I just wanted to ask you just about a couple of things. The first is that were you aware, because it's in the document which is PAGR 5028 at page 2, that on the 20th of October, when he was really awaiting being discharged, he had an unexplained injury to his face.
I didn't actually notice that. I mean, I saw him at the wardroom, so I can't really recollect whether there was a plaster or whether there was any visible injury there.
Well, it's there in the note, isn't it?
Yeah, it's there in the
MDT
note.
feedback at which you were present.
Yes, yes.
It says he reported he'd fallen over.
Yes.
And that he had a cut to the bridge of his nose. And that had occurred over the weekend, hadn't it?
No, my understanding is that it occurred the night before, so...
Somewhere the night before, then?
Yeah, so my...
Before he was actually discharged?
Yes, so... Yeah, so this is dated 20th, so this might have occurred then on the 19th night, isn't it? So,
well, who knows, because you didn't ask the questions, did you?
yeah, I mean, I didn't notice, so when he attended the discharge meeting, he didn't have any sort of a plaster or anything visible, so I didn't really explore on that.
Well, it says here in the MDT feedback that he accepted a plaster. So it looks like that was done.
So it seems like it's...
Just listen to my question.
Yes.
He accepted a plaster. So that was done. It looks like it is on the clinic, 20th of October. And that looks like you were present at this review, medical. If we look at the previous page, there's the nurse and the medical, you're named on that. So before he's actually discharged, you have this unexplained injury. Did you ask about that?
No, I didn't.
Because I think you told me earlier, or told the inquiry earlier, that nothing untoward had happened on his leaves prior to being discharged.
So, I mean, when I kind of, reading these reports, so my understanding was that something had happened overnight when he was at Priory, and he came to the nursing station the following morning and asked for a plaster, and that was given. That was my understanding, not that anything had happened in the community. If that was the case, then that would have been picked up.
When he left, was he allowed access to the hammer that had been put in his locker?
Well, so with the hammer, so if that belongs to him, so whatever he brings to the hospital, if it belongs to him, I mean, other than something like a sharp weapon or completely inappropriate, it would have been returned back to him because it's his personal property. It's in his inventories, would have been given back to him.
But you didn't ask any questions, and you didn't. You seem to have accepted this account of putting up pictures or something on the wall.
Yes, I agree that I haven't really explored further onto that. He's given an explanation. We discussed among our team that we need to remain vigilant whether he would, present as paranoid. So there were no evidence or indications that he remained paranoid over the last couple of weeks or longer.
Well, he'd simply disappeared into his room, hadn't he, largely?
Not necessarily. I mean, he did attend for his meals on a regular basis most times. He did attend to the clinic to receive his medications. So he was visible.
Yes. All right, thank you.
Thank you.
Right, we'll finish there and we'll start again tomorrow morning at 10.